Good morning, everybody. Happy Thursday, I believe it is. Welcome to TCF Live. Good to have you all here. We're going to start our day in Allegan County, Michigan, a community known for having one of the best, if not the best, county fairs in the state of Michigan. The rest of what they're known for, we'll just ignore all that. This is Judge Joseph Skokelis, or Koselis, one of those.
Is Ms. Villarreal present? I'm guessing she's still in custody. Okay. Any impact statements she filed with your office prior to being arrested, Mr. Duffield?
Yes, Your Honor, I do have a impact statement for this one.
Okay.
Ms. Villarreal states, I personally do not feel like a victim to Cicero Crowder. I do not feel he is an abuser. I feel things just got out of hands on both sides. And unfortunately, because of court-ordered no contact, he's not able to cede his babies, which is messed up and wrong because he was and always has been a good father. And my baby deserves to see her biological father. I was not injured emotionally, physically, in any way. He did not harm or hurt me. I know he had no intention of hurting me. If he really did, then he would. He only grabbed me to startle me. He thought I had, and because he thought he had a reasonable suspicion, I was in possession of his phone because I had placed it next to me on the bed after holding it. I was not able to grab all of my things due to the cops not having enough room. I left all my baby's clothes and all of my clothes as well as my dog for compensation. She just wants to get her things back, but we have no official or formal restitution request. I don't think this misunderstanding calls for any payments or severe punishment. I asked the judge to consider leniency with Cicero because of his good nature. He's a real sweet guy. Things just got out of hand due to me threatening to break his phone. I think he needs some therapy, anger management. I think he would benefit from consistent counseling. Like I previously said, Cicero is and always has been a good person. I just provoked an argument by constantly pestering him. I do not like how the cops took Cicero. I asked them not to press charges because it was just a big misunderstanding. If Cicero goes to jail, he would miss out on his first and only kid's life. It's not only important for Natalia to see her dad, but for him to be present in her life in as many ways as he can. He's always made me feel safe and loved. And that's what I have for the court. Thank you.
Mr. Crowder, this is your chance to tell me anything you would like to for your sentencing as well.
Your Honor, I am unable to hear any conversation in the courtroom.
He's not saying anything right now.
Oh, okay.
Mr. Crowder, you don't have to tell me anything, but if you'd like to, this is your chance.
Yes.
Not hearing anything. So, Ms. Strasser, on behalf of your client, you're sentencing.
Thank you, Tess Strasser, appearing on behalf of Mr. Cicero Crowder. I think the events of yesterday and the statement today show this is just unfortunately a very toxic relationship that it has broken down into, with both parties having different responsibilities and having different levels of incidents that have occurred. Mr. Crowder did take responsibility by entering a guilty plea for his actions that day. He knows he made a mistake and he wants to be able to move forward from it. As stated, they do have a child in common that he raises and supports as well. So we would ask the court to take that in consideration when moving forward. We would ask for fines and costs and a short term of probation. Thank you.
Concern with probation is you don't follow orders because you didn't follow the court's orders on bond, which was to not have any contact with her. Having contact with her caused the police to come out yet again, and she got arrested and you got arrested. So we're going to look at more orders here for probation, which I kind of doubt you're going to follow anyway. But in any event, on the charge of domestic violence first offense, we'll place you on probation for a period of 1 year. And that will be with domestic violence counseling as directed by the probation department. Condition of bail, which you violated yesterday, is going to be continued as a condition of probation. That's no contact with Lamaya until further order of the court. As you will understand, that's no contact with her. You can have contact with your child. Okay? She may not give that to you, but that's a matter for the family court. All right? So under this case, only you and her can't have the contact, not prohibiting any contact whatsoever with children. Because of your conviction for domestic violence, you no longer be able to own or possess any firearms for at least the next 8 years. That will also be a specific condition of your probation as well. The charge of domestic violence, the fine is $300. Court costs are $300. State costs and fees are $125. There is a $360 oversight fee for that term of probation, for a total of $1,085. Court file shows you were originally released from jail after posting a $3,000 surety bond. So all of that money is still due because what you paid stays with the bondsman. But you will have the entire time on probation to pay that amount on a monthly payment plan set up through the probation department. At this point, Mr. Crowder, our probation department is going to get the file and we're going to have you go down there and meet with them. Hopefully this goes better than your conditions of your bail. Hopefully this is the last jail time you're going to do that you just did yesterday. Okay? Good luck, sir. Thank you, Mr.
Your Honor, I apologize. How long is the term of probation?
1 year. 1 year.
1 year. Thank you.
Your name, sir?
Philip Burley.
He's here for
thank you.
space.
Okay.
No, sir.
On the telephone.
Make this a loud here like that. Okay, let's not do that. I don't want to see that on that process.
Hello,
Hello. What is
Yes.
your name?
Mark Kimes, Keim.
All right, there's a lot of background noise.
All right, I'm trying my best to give a better signal.
Mr.
better?
Kime, you're going to have to go someplace else where there's no background noise, or I'm going to have to adjourn this and have you come to court in person, okay?
Okay, is there background noise now? There's nobody around, nothing.
There is
Quiet.
not. This is file 253684SM, People versus Mark Richard Kime, here today for sentencing. Charged in this case with a charge of assault and battery. And on January 29th, you entered a plea of guilty to that charge. Prosecutor's office requested we set this for sentencing at a later date for crime victim rights purposes. Mr. Burley, if you would have a seat up here at the table so we can record this. Mr. Burley is present in court today. Mr. Burley, this is your chance to tell me anything you'd like to regarding what Mr. Kime's sentencing should be today.
Thank you, Your Honor. I'm Philip Burley, the victim of this assault case. Mark Keem has been a verbally and a physically abusive, vulgar man. He has assaulted me on 3 different dates and only been charged for 1 so far. Mark thought he was entitled to live in my rental home rent-free. He thought he was entitled to verbally abuse and physically assault me in front of my special needs son while we were on a walk in this case. Mark has been evicted out of my home and convicted of assaulting me. A darkness has been lifted out of my property and our neighborhood since the eviction. Mark has some real anger issues that need to be addressed. Mark has hit my phone out of my hand 7 times and damaged my phone. Mark needs consequences for his behavior, and I would hope for jail time and restitution for my phone. I do forgive Mark, but I feel he really needs some mental health help. Thank you for this opportunity to share my thoughts and hopes.
Do you have any damage repair receipt for your damaged phone?
I turned in a cost of a new phone.
Well, that's not what you're entitled to. You're entitled to reimbursement for what you lost. So if you lost a 5-year-old phone, you're entitled to the value of that 5-year-old phone. You can't come off better than you were.
Yeah.
So in other words, we'd have to know what the fair market value of the phone was, if it was destroyed or if it was repaired, what the damage cost was. The probation department, if you want to get with them later, can have you fill out an amended form, but you will not get the replacement cost of a brand new phone, only what the phone's value was when it was lost. Mr. Kime, can't see you. Are you still with us?
Yes, sir.
This is your chance to tell me anything you'd like to for sentencing as well.
All right. He has assaulted me with his leaf blower, which police documented. He broke my glasses and broke the screen on my phone that I had in my back pocket. But he hit me with his leaf blower because he come over to where I was staying with Amber, my roommate, and she's terrified of him. He's got cameras pointing into the house. He's got brush piled up outside the front of the door and the backyard, so he can go behind all this brush and watch, and whatever he does, I don't know. But she is scared of him, and I did knock the phone out of his hand 7 times. It was only once or twice after he hit me with it, and I didn't want that to happen again. So yeah, I knocked the phone out of his hand because I'm guilty of that. I already pleaded guilty to that.
Mr. Kime, one question I had for you after looking over the materials I had for sentencing. Do you currently hold a Michigan CPL?
No, I don't. I don't have none left. No, I don't.
It's not a tough question. Do you hold a Michigan concealed pistol license? Yes or no?
No.
No, do
I
not.
don't.
Okay, because I saw in the materials that you were fingerprinted for one. Did they not give you one?
Yeah, I did, but my home burnt down and I lost everything, so I don't have no use for it. I don't conceal pistol anymore. I don't have anything that got burned up.
All right, I just have to verify that because an assault of conviction would cause a loss of that, and it will probably cause you to not get one in the future for a while. So, okay. Ms. Fogel, on behalf of Mr. Kime for sentencing.
Thank you, Your Honor. Yes, this situation came about from a landlord-tenant dispute with a lot of history, as I'm sure you've heard today. It has included arguments that ended up with Mark also being hit with things like a leaf blower or a phone in the past. And this particular interaction began with the complaining witness filming Mark without his permission or consent. They had gotten into an argument that escalated. And if Mark could go back to that day, he would have walked away and he would have called the police when he felt like he was being harassed. He would not have handled the situation himself in a physical way. Mark no longer lives at the address where this occurred, and he no longer lives anywhere near the complaining witness. Mark is also 64 years old and has had no criminal record prior to this incident. The prosecution was comfortable agreeing to a sentencing recommendation of no jail, and we would request fines and costs only in this matter. Additionally, Your Honor, if possible, we would request that the court minimize fines and costs as Mark is currently homeless and is working on regaining stable housing. Thank you.
Looking at his criminal history, I'm showing Mr. Kime has a half dozen misdemeanor charges. Some of these are fairly recent, 24, 24, 24, 24. First assaultive offense. In any event, I am concerned about an assaultive case, and we have a situation here where the victim is requesting no contact with him. Based on those facts, I do feel a short term of probation is required here. We'll place Mr. Kime on probation for a period of 6 months, and that will be with counseling services as directed by the probation department. condition of probation will be no contact with Philip Burley until further order of the court, which means Mr. Kime would have to literally sign an amendment to your probation order. The fine on this charge of assault and battery is $300. Court costs are $300. State costs and fees are $125. There is a $180 oversight fee for that term of probation. And at this point, again, I don't have a restitution amount for any phone damage because we have to use the statutory basis, which is the fair market value of the phone at the time it was damaged or destroyed. But that could be an amendment to a probation order at a later date. With that, sir, we are going to send your file down to the probation department. They're going to contact you before noon today, hopefully, and start to set up that probation order with you. What telephone number can they reach you at today?
I just got a new phone. 467. I'm sorry, I should have.
Take your time and look at the phone and see what number is on your new phone.
Okay, if I do know how to use it. I don't use this phone for much. Yeah, no, I can't get into it. I wouldn't know how to even look it up.
Ms. Fogel, do you have a telephone number for your client?
Yes, Your Honor. Mr. Kime is currently staying at the Gateway Men's Home, so I do have the phone number for them to be able to get in contact with him.
I'll give that to probation then.
Okay. Would you like me to read it now?
Go ahead.
269. Oh, I apologize. Let me make sure that's the right number. I have a couple. Okay, sorry. It's 616.
So Mr. Khan, the probation department's going to call that number looking for you. So if they don't contact you, be aware that they're looking for you. You can always call the court and speak to them, but they do need to contact you to set up that probation order. If they're unable to do it on the phone, they're going to have you come in person, which is going to be a bit of a drive for you. So try to be available at the telephone number you just gave us, and they will contact you at that number. Good luck to you, sir.
All
Thank
right.
you, Mr. Good luck to you, Mr. Burley.
Thank you.
Again, contact the probation department if you have any repair figure for that phone, okay?
All right, thank you.
And they will tell you who the probation officer is, okay?
Good morning, everybody. Once again, TCF Live on a Thursday. Good to have you all here. I'm just kind of sitting here chuckling, just a little bit of background information. My ex-wife's family, most of them reside in Allegan County. So when I hear stuff like hitting somebody with a leaf blower and I got a new phone, but I don't know how to use it and all that kind of stuff, it tracks with this community just perfectly. I am incredibly familiar with this community and yeah, totally fits. Let's stay with them for just a little while longer. Other courts are starting to come online, so we'll move shortly, but we'll spend a couple more minutes here.
I'm the probation officer.
Very good, thank you.
Didn't they just have a trial in D reversed where he was a defendant, this victim, and the other guy? I'm serious. I mean, I remember they just tried a case involving Philip Burley. I'm not guilty, but I remember that was down in their courtroom. Jeez. Yeah, this is a
Caleb Bruchart, can you hear me?
Yes, I can.
about 254005 SM, People versus Caleb Lee Bruchart, here today for sentencing. Back on January 30th, a plea of guilty was taken under advisement on a charge of domestic violence. At that time, the prosecutor's office requested we set this for sentencing at a later date for crime victim rights purposes. We have no one in the courtroom. Is Kalea Cassandra Pardee present at your office, Mr. Duffield, or has she filed any type of an impact statement?
Yes, sir. We have an impact statement to read for the court.
Go ahead, sir.
I, Kalea Pardee, am writing a victim statement on behalf of Caleb Bruchart. I was dating Caleb off and on for a while. When I didn't do or say what he wanted to hear, he would get very angry and get in my face and start yelling and even pushing me often. The worst part about being with Caleb was the mental abuse. He would make me delete everyone on social media he didn't want me to be friends with and monitor my phone. He would also make me stay on FaceTime or speakerphone when I was at home so my mom and dad could not have a conversation he didn't know about. He said my parents were trying to turn me against him because they would not let him live with us when he did have anywhere to go, or even let him in our house because they have heard he steals everything he can get his hands on. Many times my mom would catch him on the phone when she was talking to me and she would tell him to hang up. He would tell me right in front of my mom, I better not hang up the phone, so she would grab the phone and hang up on him. He would call back over and over again, and my mom would try to tell me he was crazy and that wasn't normal. When I talked to him later, he would cry all day, trying to make me feel as if I didn't care about him, and would try telling me my mom and dad did not love me and how horrible they were to me, and he was the only person who truly loved me. He tried his hardest to turn me against my parents. Caleb is not only mentally abusive, but physically as well. He choked me, he hit my head on a bed frame, he pushed me, and damaged my car due to being angry. On the day that Caleb damaged my car, we were arguing at his friend's house because I told him I didn't think it was going to work between us. I decided to leave, and so I went to my car. Caleb grabbed me by my hair, dragged me back to the house. I got away from him again and locked myself in the car and was trying to get out of there. And that's when Caleb started kicking my car and yelling at me to open the doors. I was terrified that day watching him do all of that damage to my car. I could only imagine what he would have done to me if he had gotten me out of the car. Being with Caleb has impacted me in a very negative way. I have a hard time trusting people. He has also made things difficult for my parents and I due to calling my mom after we stopped talking with his friend's phone, threatening her and saying if he had the chance, he would damage my car again, and he's going to do the same thing to their cars. I think Caleb could use anger management classes and some professional help with abuse on others. And then I do believe that we have a restitution request for the damage to the car in the amount of $4,623.31. I believe we have sent those documents to opposing counsel. I don't believe alcohol. I don't believe alcohol or controlled substances were involved, Your Honor.
We have nothing in the court file, and how is restitution for a vehicle going to be tied into a domestic violence on her? There's no charge for any malicious destruction of property.
I understand, Your Honor. This is what we received. My understanding of the facts parallels the impact statement that there was damage to the car right at the same time as the domestic violence incident. So I'm happy to proceed on that point as the court sees fit.
Okay, well, again, just to clarify, there was no charge for any damage to the property, only for the domestic violence, correct?
That is correct, Your Honor.
All right. Mr. Brouchard, are you able to hear me?
Yes, I can.
Can you turn your video on for us so we can see you? You're on the telephone.
I don't have a.
Nope.
Yeah.
You're on the telephone, I was told. So this is your chance to tell me anything you'd like to for sentencing. Were you able to hear the statement that Ms. Pardee gave?
Yes, I did.
Okay, this is your chance to tell me anything you'd like to as well.
Well, I mean, I don't have a lot to say other than the day that all this happened. A lot. I mean, I don't know if you want a story from me or not. So I don't know.
I don't want anything, sir. This is your chance to tell me anything you would like to for your sentencing.
I mean, I really wouldn't like to say anything, Your Honor.
That's fine. Ms. Vogel, on behalf of Mr. Brouchard.
Yes, Your Honor. The day this incident occurred, Caleb and his girlfriend had gone to the mall together, had a nice day. He had even bought her a ring that day. However, later in that day, she found out that she had cheated on him multiple times, leading naturally to an argument. She broke things at the house he was staying at and left angry before coming back again and starting to throw his things out of her car, at the house, and on the ground. Caleb was upset. He was angry. He was pushed his limits and he reacted without thinking. He did grab her by the shoulder and pull her out of the car, as he did state as factual basis in his plea. As I said, Caleb was upset. He was angry, but he knows that if he is in this situation again, he will not handle the situation himself. Instead, he would walk away. He would call the police to have them come instead. Since this incident, Caleb has been focusing on being a good father to his 2-year-old daughter, getting a new full-time job at the McDonald's in Portage, purchasing his own vehicle, and spending time with his family. He has goals to save up for his own apartment and obtain a higher paying job, ideally somewhere where he can work outside, possibly with asphalt or concrete. Caleb has not been convicted previously of an assaultive crime, and the prosecution felt comfortable recommending the diversion program. Thus, we would request the court impose only a short period of probation in the domestic violence deferral program. Additionally, Your Honor, on the subject of restitution, as you stated as well, Mr. Bouchard has been charged and convicted of domestic violence, not of any destruction of property. Mr. Bouchard provided a factual basis for his plea, in which he admitted to grabbing the complaining witness and pulling her out of her car. No other conduct has been proven by the people, and Mr. Bouchard cannot be required to pay for damage to property that he was not charged for or convicted of under People v. McKinley. And restitution is intended to make the victim whole and compensate for actual loss suffered by the victim. The person requesting restitution in this case, by my understanding, is the father of the complaining witness, not the complaining witness herself, a third party, and thus is not a victim in this case, but rather a third party. Thank you. If you do choose to impose restitution, we would be requesting a formal restitution hearing on the actual amount, as what was provided to us was a preliminary estimate that included repairs far beyond what would even arise from any conduct alleged in the police report.
Mr. Bouchard, the prosecutor's office would have to charge you with another offense for malicious destruction of personal property, which they very well might do now, but in any event, that's not going to be part of your case here today. You're just here today on the charge of domestic violence. Looking at your history, minor vaping, minor marijuana case, 2 careless driving cases, both reduced from recklessness, both from a few months apart last fall. I'm not sure what's going on there, but on this case, it appears to be your first assaultive offense. In any event, the prosecutor's office is going to give you essentially a slow dismissal on this because they're offering you a first offense deferral, which means the case is dismissed at the end. The deferral program is a 1-year program, so you are going to be placed on probation for the next year. Condition of your probation, first of all, is no contact with Kalea Pardee until further order of the court, which means I would have to sign an amendment to your probation order to allow that. So even if she changes her mind, you'd still be in violation of your probation order, and you could risk having the deferral set aside if you had contact with her before your probation order is amended. They will also have the authority to provide counseling services as they see fit for domestic violence or for any other purpose. The cost of the deferral program, that 1-year term of probation, is $625. Court file shows you released from the Allegan County Jail on a $500 PR bond, so all of that is due. But you will have the entire time on probation to pay that amount on a monthly payment plan set up through the probation department. The probation department is going to contact you this morning to set up your probation order. What telephone number can they reach you at today, sir?
269-430.
You are free to hang up from the court proceeding. Be available at that telephone number. Our probation department will contact you at that number shortly. Good luck to you, sir. I hope this all works out successfully. Thank you, Ms. Vogel.
Thank you, Your Honor.
Thank you, Your Honor.
What was the total fines and costs on that one?
It's not a fine and cost. It's a probation oversight fee for the 1-year term of probation of $625.
Got it. Thank you.
That's the same for any DV deferral.
Okay. Thank you. I appreciate that.
Okay, friends, other courts are starting to come online right now, but this is This is the most compelling thing at the moment. So we're going to stay in Allegan County probably for at least one more case.
Yep, I can hear you guys fine. Can you hear me?
Yes.
Okay.
File 254319 SD. File 254320 ST and file 254335 ST. All three cases were set today for sentencing. The court file shows that on January 16th of this year, entered a plea of guilty to a charge of operating while intoxicated, second offense. That charge carries mandatory jail, so I did order a pre-sentence investigation, and the probation department indicates you failed to respond to any of their requests to have that pre-sentence investigation done. That could result in a bench warrant for your arrest for your failure to comply, but I did tell the probation department we were going to leave this on for sentencing today to see if you appeared. You have appeared. We can't do anything because you were ignoring the calls from the probation department. So right now, what telephone number are you at, sir?
989-93.
989.
Yep. 935.
935.
2780.
2780. Don't go away from that telephone number. The probation department's going to contact you at that number, and they're going to start the process for the pre-sentence investigation. If they cannot contact you today for some reason, you contact them. If we don't have any contact with you by the close of business today, a bench warrant will be issued for your arrest, and they would do the pre-sentence investigation while you're in jail. So you understand how important this is, Mr. Kenyon?
Yes, sir.
Okay, you cannot ignore them any longer because you're right down to getting a bench warrant for non-compliance. So do it the easy way. They're just going to call you. They're going to go over some things with you over the phone, and they will then prepare a pre-sentence investigation. We are going to have to adjourn your sentencing for a later date, probably another 30 days, because they'll have a need to get a lot of materials together for your pre-sentence investigation. They are then required at least 2 days prior to sentencing to send that to your attorney, and then she'll have 2 days to go over that with you prior to sentencing. Sentencing will be on a Thursday morning just like this, and we'll be able to do it over the Zoom. Are you still living in Mount Pleasant?
Yes, sir.
So the address we have is current?
That is correct.
You are free to hang up the court proceeding. Again, your files are going down to the probation department. They'll be contacting you at the number you just gave us shortly. Okay?
Thank you, sir. Appreciate you.
Thank you.
Have a good day.
Friends, that half an hour or so we just spent in Allegan County, it's all so familiar to me. It's an interesting community. We'll just leave it at that. Let's head out though. Let's go to Ohio. Judge O'Donnell. Let's see what's going on there today.
I let my anger get the best out of me at NeoCap. I did 40 days, and I know you gave me a shot at probation and a program and whatnot, and I took the help when you offered it to me rather than go to prison. I had an altercation with one of the staff members, and
what was the altercation about?
He wrote me up for something that I didn't do, and I called him out of his name. So basically, I let my anger get the best out of me, and it's something I need to work on.
What do you mean you call? What do you mean you called him out?
I called him a bitch.
Is he a bitch?
I mean, no, obviously, no, he's not. I just
then why'd you call him a bitch?
I let my anger get the best out of me, Your Honor.
Right. And then as a result of that comment, they threw you out?
Yeah, yep, they kicked me out. I think I did 42 days maybe. So I was just getting into the majority of my classes.
Well, you started, once he wrote you up, he was walking to the central control and you followed him. Stood in the doorway of central control. began challenging the staff member and calling him names. Then you walked around the upper level, continued screaming, "You're a bitch, fuck you," which alerted other residents to what was going on. Supervisor tried to talk to you to get you to lower your voice and control yourself. And from that, you escalated in the same behavior. They told you what you had to do to comply. You said you weren't going to comply. You were done with the program. Went to an unapproved area, refused to leave. Kept saying, "You're done with the program. Take me back to county." So they perceived you to be a bit of a threat. So you were taken out.
Yes, Your Honor, all that is true, except they took me to my room. I went to my room after all that happened, and they're like, "Are you gonna chill out?" I said yes, and I tried to calm down. I took a nap, and I was just trying to let it just pass over. When I woke up, I was gonna get up and apologize to the staff member for acting the way that I did, but me saying I was done with the program, I might have said that one time, but they had calmed me down, and I wanted to continue the program and just get it over with.
Well, you wanted to continue the program and just get it over with? Why wouldn't you want to continue the program and get something out of it so that you don't keep coming back here?
Well, I mean, that is
year
well, Your
after
Honor.
year after year.
I would, if you could possibly put me into another program, I have.
What kind of program? What?
I mean, some kind of anger management class or any kind of program like that.
Well, the problem is, why do you need an anger management program? Why?
I mean, I guess it was more. I have anger issues. I do.
What are you angry about?
I feel like all of that stemmed from where I was at. I'm not just like an angry person out on the streets. I don't just go up to people and say, start cussing at them. Like, I'm rarely ever angry in
Well,
that
if you
sense.
did that, you'd be in the mental hospital.
True.
I mean,
Yeah.
So what's the source of all? You said the stuff in your past. What stuff? What stuff?
I mean, it's just my drug use. That's what got me angry. Just being a failure at life. Just not being where I wanted to be at in life. That's what got me angry. But me, like, having this.
Where do you want to be at in life?
I just want to be successful. I want to hold a career. I want to stay at a job for more than a year. I want to raise my son. I want to teach him how to be a man and instill the values and morals that, my father had given me into him. And I mean, I just
How long have you been going to Signature Health?
I started going there again this year. I was out for 8 days. I had gotten bonded out on this felony case, and I was out for 8 days, and I signed up for their program there, and then I came to court on the 1st, and I was sentenced to NeoCap, so I didn't get to follow through with them.
What are those records? What's the time frame on those records, Kim?
Your Honor, it goes all the way back to 24.
Okay.
So he's been with them probably off and on for quite some time.
And what do they say your problem is? What were they? Okay. So what kind of substance?
Substance abuse, and it's a dual disorder, anxiety and depression and whatnot. But I believe that stems from my drug use.
Okay. So what was the plan to do something about it?
I got on their MAT program, which I've been on.
Which is what?
Suboxone, and I've been taking that regularly.
What's this methadone crap?
So I got off of methadone. I got on it when I was in Minneapolis, and I ended up getting off of it just because I just didn't like the side effects on it, and I could still use on it. I wanted something that could block.
When were you in Minneapolis?
I was in Minneapolis in 2020 after I got out of prison. I went out there, went to a sober house, stayed out there for 1.5 years, and then moved to Columbus, got in the laborers union, and now I'm back in Lake County.
Okay. What was the name of that place? Sunrise something or other, Kim?
New Season.
New Seasons, same thing. When did you go to New Seasons?
New Seasons, I don't.
In Menor.
Oh, New Seasons. Oh, the methadone clinic there. I was there. I think when I came back from Minneapolis, I tried getting in with them, but I got in with another program.
The methadone does what, theoretically?
It helps with your cravings
For
and
opiates, right?
Yes, opiates.
Not meth, right?
No.
So you get around the opiate blockers with meth in the past?
Yeah, you definitely can use meth on opiate blockers.
Okay. So what's the point? What's the point of taking a drug that's going to keep you from using a drug if you're going to use other drugs?
I don't plan on using other drugs. I mean, it was just that lifestyle I was living. Like that's not the person I am, Your Honor. I'm not a drug addict. That's not my name.
Well, you are, right?
Oh, I'm a drug addict, but I don't let that define me, and I do not want to go back to that life. Okay. So I'm going to do anything that I can to stay away from that kind of stuff.
Well, part of that plan was NeoCap.
Yeah.
It didn't work. So I'm trying to figure out, with the help of Jim and Kim, to figure out what could possibly work when nothing has worked. How long were you in prison? Not long, right?
6 months.
Okay. Was that a pleasant stay?
No, absolutely not.
Okay.
It did nothing for me.
There should be some motivation not to go back there.
Absolutely.
It isn't intended to do anything for you, by the way. It did exactly what it's intended to do, nothing. Put you somewhere for 6 months that you can't cause any havoc out here. That's what it's designed to do. It's not designed to help you. You have to help you. If you don't want to help you, then you ain't gonna be helped. Sounds simple. It is simple. So I have no idea what to do with you at this point. All right, we're gonna come back for the final hearing. And maybe between me and Jim and Kim, we'll be able to figure out if there's anything that can be done for you.
All right. Is there anything I should be looking into, or?
Well, I think what you need to look into is figuring out what exactly you want to do with your life and figuring out in an honest manner what you have to do, what steps you have to take to get to that end. That's what you have to do.
All right.
See you next time.
All right.
Okay, friends, good morning once again. TCF Live. It's a Thursday. It's great to have you all here. And by the way, I didn't think I said it earlier, and I apologize for that, but Barbara, thank you for the $5 super chat. And continued prayers for Nina and her son and Wahoo and his family. So I appreciate that. Let's take our standard morning pilgrimage down to Florida. Wade Mercer.
Probable cause in the complaint, but you have a perfect criminal history, at least before this arrest. You've never been charged with a crime anywhere, as far as I can tell. Mr. Ware, is that accurate? You've never been arrested before, right?
Yes, sir.
Mr. Ware, I'm going to appoint the public defender's officer to represent you for first appearance purposes. Listen to Mr. McDaniel, and he's going to tell us where we're going today.
Your Honor, we just asked for a conditional release and set him on the next court docket.
Mr. Mitchell?
No objection to a conditional release, but I assume he's probably going to get a valid license before the next court date. But until then, we just request no driving without a valid DL.
So, Mr. Ware, I always give people a choice. If I offer them a conditional release, some people prefer a bond, so I always give that option. If you want to post a bond, in your case, I would set you $1,000 bond. But if you want to accept the conditional release, that's perfectly okay. If you accept the conditional release, you'll have the standard conditions of every release, plus the condition that you not drive a motor vehicle unless you have a valid license. You get your license straightened out, you drive all you want. Mr. Ware, the jail's going to give you a notice for your next court date, which will be March 2nd.
I think we're still in that
March
cutoff.
2nd.
Yeah.
March 2nd at 9 a.m. will be your court date. I can tell you something else about that in just a second. But first, do you have any questions about the choice between the bond and the conditional release?
No, sir.
And you want to choose the conditional release, is that correct?
Yes, sir.
Okay, so let me tell you, your friend, what's going to happen next. So, sir, what's going to happen is they're going to let Mr. Ware use the phone if he wishes to. Then they're going to bring him to the courthouse because that's where the conditional release office is at. It's downstairs inside the judge's office on the east side. He'll meet with the conditional release officer. They'll go over the conditional release with him. They'll see if he has any questions. They'll give him a copy of the rules in writing, and then he'll be free to go. Usually that's about 30 or 45 minutes it takes to get him from the jail up here and get instructed. So are you going to be able to pick him up? Your friend says he's going to be here to pick you up, so you don't have to worry about that. Mr. Ware, Mr. McDaniels, I'm sure he's told you this already, but Mr. Mitchell, especially if someone with no prior history, he will commonly dismiss these cases if the person gets their license straightened out before the court date. So do your best to try to get the license straightened out before the court date. And if you provide it to Mr. McDaniel's office, or actually you wouldn't be important, we provide it to you or to the state.
I already told him to take it to my office, so.
If you get to his office, they may even cancel your court date, Mr. Ware. So this case will be dismissed, hopefully. Do you have any questions, Mr. Ware?
Sir.
In the courtroom, do you have any questions, sir? Curtis, any questions? All right, wish you the best, sir.
Okay.
So he'll be downstairs probably 30 to 45 minutes. Yes.
He had a headlight out, so could be a civil case court.
I see in Nicholson.
Like I said,
Yeah. We'll see.
Mr. Nicholson, good morning. Mr. Nicholson, you're here for first appearance accused of one count of disorder intoxication. There is probable cause for the charge, Mr. Nicholson. I'm appointing the public defender's officer to represent you, and I'm going to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Nicholson. At this point in time, he's going to enter a plea of no contest to the charges listed. With the understanding he'll be sentenced to 10 days in the county jail. There'll be a $370 fine. He'll have 2 days jail credit. He has signed his plea waiver form, waiving his right to a jury trial and call witnesses.
10 days, 2 days credit, 370. Mr. Mitchell, is that agreeable with the state?
That is agreeable, Your Honor.
And Mr. Nicholson, did you hear that agreement, sir?
Yes, Your Honor, I heard that agreement, sir.
Mr. Nicholson, is that the plea that you would like to enter?
Yes, sir.
Mr. Nicholson, I'm going to accept your plea of no contest then to that one charge of disorder intoxication, withhold adjudication of guilt. Actually, I don't have a criminal history. I don't know that matters. I'm going to withhold adjudication of guilt unless there's
He's got a criminal history.
Is the state wanting him adjudicated?
Yeah, yes, Your Honor.
Okay.
He just
And
recently.
that was the agreement, Mr. McDaniel.
That's fine, Your Honor. Yeah, I mean,
I'm going to adjudicate you guilty then as pursuant to the agreement that y'all reached. 10 days in jail will be your sentence with 2 days credit, 370 court costs and fines will be imposed. Mr. Nicholson, that means you have 8 days left at most. The reason I say at most is you may do a day or two less than that under Florida's game time laws by following the rules at the jail. So I would encourage you to talk to the jailer about that, but there's no probation involved, sir. When you finish this sentence, you'll be released. Do you have any questions, Mr. Nicholson?
I have no questions.
Wish you the best, sir.
Thank you.
Yes, sir. We have Coy Jennings. Mr. Jennings, good morning. Mr. Jennings, you're here for first appearance accused of one count of aggravated fleeing and eluding law enforcement and one count of driving while license suspended or revoked. That aggravated fleeing and eluding is a second-degree felony. Mr. Jennings, there is probable cause for these charges. Your criminal history is not good at all. I think you've been to prison in Florida 4 times. Is that right, sir?
Yes, sir.
So, but you're still entitled to a bond as far as I can tell so far. So let me listen to the attorneys and I'll set your bond. Mr. McDaniel, anything on behalf of Mr. Jennings? No, Mr. Mitchell?
We just request you have a condition of no driving at all.
Mr. Jennings, your bond's going to be $25,000 on that second-degree felony because your criminal history is so bad. Your bond on the other charges, that's just a misdemeanor. That's going to be $2,500. Mr. Jennings, your total bond is $27,500. It does have a condition not to drive a motor vehicle for the reasons, the seriousness of the complaint, the allegations of the speed, and the driving record. Mr. Jennings, you'll get to use the phone in just a minute, sir, and try to post the bond, and you'll be released as soon as you post it. If you're not able to post the bond, the public defender's office will be in contact with you at the jail. The jail is also going to give you a notice for your court date, March 3rd.
Yeah, March 3rd.
Your court date will be March the 3rd at 8:30, sir. They'll give you that written notice. Mr. Jennings, any questions?
No, sir.
Wish you the best, sir. We have John Barfield. Mr. Barfield, good morning. Mr. Barfield, you're here for first appearance accused of 1 felony and 3 misdemeanors. The felony charges felon in possession of a firearm. The misdemeanors are all game violations. One is taking deer from a right of way. One is taking a deer by an unlawful method based upon the season. And the third one is a violation of the general method of taking games. It has to do with, I think it had, the best I could tell, it's a little confusing, but it has to do with the method in which the animal was stored after it was taken. So there's 3 less serious charges and 1 very serious charge. You do have a criminal history that's very lengthy, and you've also got a prior felon in possession of firearm, but I believe that case was dismissed several years ago. So I think you're entitled to a bond, Mr. Barfield, as far as I can tell. Let me see what the attorneys have to add, and then I'll address that bond status. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Nothing from the state, Your Honor.
Mr. Barfield, on that 1 second-degree felony, your bond's going to be $25,000. On the misdemeanor charges, your bond's going to be $2,500 each. When you add those together, your total bond today is $32,500, Mr. Barfield. Cash or surety. Cash or surety means you don't have to come up with all that money. You can go through a bondsman, sir, and you'll get a chance in just a few minutes to use the phone to try to post the bond. You can't possess a firearm, so I'm not going to add a special condition to that. You can't possess one anyway because you're a convicted felon, allegedly. So just be aware of that. The jail's going to give you a notice for your court date. It should be March the 3rd at 8:30. And you'll get a chance to use the phone in a few minutes to try to post the bond. Mr. Barfield, do you have any questions, sir?
No, sir.
Wish you the best, Mr. Barfield.
Thank you.
We have Brianna Knight. Ms. Knight, good morning. Ms. Knight, you're here for first appearance accused of 1 count of failure to return hired or leased personal property valued at more than $300. That's a felony charge. Ms. Knight, I went back and refreshed my memory. I think I'm the judge that signed this warrant back in August. And I think it's a television and some kind of gaming system that they say that you rented and didn't return and wouldn't respond to their attempts to contact you. The good news is, as far as I can tell, you have no prior criminal history. Is that right, Ms. Knight?
No, sir.
That's excellent. That's going to help you. Let me see if the attorneys have any additional information before I address your bond or your release status. Mr. McDaniel?
No, we just asked for a cash bond.
Mr. Mitchell?
No objection to a cash bond.
All right, so Ms. Knight, I'm going to set your bond at, if you're requesting a cash bond with no prior history, I'm going to set your bond at $250 cash. I'm also going to offer you a conditional release because of your criminal history or lack thereof. But if you want to post the cash bond, that's fine. You have a condition, no contact with the rental agency. I don't remember which one it was. I think it was Rent-A-Center.
Yes,
No
sir.
contact with the agency that's accusing you of this till we get this all sorted out. It's a $250 cash bond or conditional release. And my understanding is you prefer the cash bond. Is that right?
Yes, sir.
So you'll get to use the phone. As soon as you post that cash bond, you'll be released. The jail's going to give you a notice for your court date in felony court before Judge Garcia, and that should be
The 3rd.
March the 3rd at 8:30. Ms. Knight, do you have any questions?
No, sir.
All right, ma'am, you'll get to use the phone shortly.
Thank you.
Yes, ma'am. Corporal, did I miss anybody? Is that it for the first appearances at the jail?
Yes, sir, that's it.
All right, that takes care of Wade Mercer's stuff for the day. Let's go back up to Ohio. We'll stay in the same building, but let's see what's going on with Judge Collada.
We're here today today in the state of Ohio versus Daniel Fursick, case number 25CR1608. The defendant is present with counsel Matt Lallo, and we're here today for a change of plea hearing. It's the state's understanding the defendant is going to withdraw his previously entered plea of not guilty and enter a no contest plea to the indictment, that being count 1, aggravated possession of drugs, a felony of the 3rd degree, and count 2, aggravated possession of drugs, a felony of the 5th degree, both with attached forfeiture specifications. The state would ask for a pre-sentence report, a drug and alcohol evaluation, and a psychological evaluation. And there is no agreement as to sentencing. Thank you.
Mr. Lau, does that all sound accurate?
That is accurate, Your Honor.
All right, Mr. Fursick, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here at this time?
Yes, Your Honor.
They indicated to the court, excuse me. They indicated to the court they believe it's your intention to withdraw your previously entered plea of not guilty and enter a plea of no contest to the charges in the indictment, and I'll go over those with you and make sure you understand them. We would then defer sentencing, if the court, assuming the court finds you guilty, get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations at this time. Each side is free to recommend to the court whatever sentence they feel is or believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and more importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand what it is you're charged with and pleading guilty to. The rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything we're doing, all right?
Yes, sir.
All right. Let's get started then. How old are you, sir?
51 years old. Yeah.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
Sometimes I do, yes, Your Honor.
Okay. There's going to come a point in time when you're going to have to read some paperwork. Can you assure the court that if you're having any difficulty reading it, any difficulty understanding what you're reading, you'll ask for assistance, you'll ask your lawyer, you can ask me, but that you'll do that because it's important that you understand it?
Yes, Your Honor.
All right. Are you a U.S. citizen?
Yes, Your Honor.
Now, before coming into court today, have you had any drugs or alcohol of any kind?
Just what was prescribed by my mental health.
And what is that? Anything that you've taken in the last 48 hours?
Clotidine, Depakote, Lexapro, methocarbamol, there's Tylenol and something else I'm taking too.
What was the one you said before the Tylenol? Not Clonidine, it was after that.
Methocarbamol.
Methocarbamol?
Yes,
What's that
it's a
for?
muscle relaxer.
Okay. So I have Depakote, Lexapro, Clonidine, Tylenol, and methocarbamol.
Yes, Your Honor.
Those are all you've had in the last 48 hours?
No, Nexium as well too.
Nexium?
Nexium, yes, and another laxative as well.
Do any of those medications affect your ability to understand or appreciate where you are right now, what's going on? They negatively impact you in any way?
Not at the moment, no.
Okay. So right now, you're not,
I understand where I'm at, is that what you're asking?
those medications are not in any way interfering with your ability to appreciate your surroundings, to communicate, to understand anything?
No, not yet, no.
Thank you. Now, you would have received a copy of this indictment. It looks like you got it sometime back in the middle of December or so. That's the document that sets forth the charges you're accused of committing. Do you remember getting that at some point?
Yes, Your Honor.
Now, in the indictment, you're charged with 2 counts. What's alleged here and what you're going to be pleading no contest to is that on or about, in count 1, October 16th, 2025, in Painesville Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine, Schedule 2 controlled substance. The amount involved equal or exceeded the bulk amount, but was less than 5 times the bulk amount. So this conduct with the amount involved constitutes the offense of aggravated possession of drugs, a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, Your Honor.
Any questions about it? Go ahead, Mr. Morrow.
No contest.
All right. I'm going to say that throughout here, probably mistakenly. I understand it's no contest plea. I know you're not pleading not guilty. I mean, you're not pleading guilty. Pleading no contest. And we'll try to remember that what I'm saying. But if I say guilty, I know it's a no contest plea, and the record's clear on that. All right.
Understood.
So,
I won't.
No, but I appreciate that. Mary already warned me about that, and I missed the fail on that. All right, so do you understand then that what it is that you're going to be pleading no contest to in regards to count 1?
Yes, Your Honor.
All right. There's also what we call a forfeiture specification here that alleges during the offense you possessed or had an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal just by the nature of the property itself, like drugs. Whereas an instrumentality is some type of property that there may not be anything illegal about in and of itself, but it's being used in an illegal manner to facilitate a crime, and you can't possess it for that purpose. And here it's alleged that there's the drugs themselves, there's methamphetamine, psilocybin, and psilocin, along with syringes and packaging. The whole point of this is that you forfeit any ownership interest you have in that property. It doesn't increase any potential penalty you face, but it allows allows the state to dispose of the property afterwards. Understand that?
Yes, sir.
Any questions about it?
Do you have any questions?
No, I mean, I don't think there's any packaging. I think they left that back in my bag.
It was like syringes, bags.
The bags, there's no, that was for my key drop bags.
What were the drugs in?
They were just in 2 baggies, but there was,
That's what I'm talking about.
Oh, okay.
Packaging,
I'm sorry.
packaging
Okay.
for the drugs and
Okay.
stuff. That's what we're talking about. Yeah. Just something that something was in, not packages, but something that was wrapped in cellophane, something like that.
Okay.
Any other questions?
Oh, yeah.
Now, in count 2, what's alleged here and what you're pleading no contest to is on or about October 16th, 2025, in Painesville Lake County, Ohio, that you didn't knowingly obtain, possess, or use psilocybin and psilocin, or a compound mixture, preparation, or substance containing psilocybin or psilocin, Schedule 1 controlled substance. The amount involved did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs a felony of the 5th degree. This has the same forfeiture specification. Do you understand what you're charged with and pleading no contest to in regards to count 2?
Yes, Your Honor.
Any questions for me about count 2?
No, Your Honor.
Well, then before I can accept your plea, I need to make sure you understand all the rights you're giving up by pleading no contest here, and you first of all have a right to a trial. Now, a trial could be to me as a judge where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty of the charges, but you also have a constitutional right to have a jury trial, which would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision. Unanimous means all 12 of them would have to agree together, one way or the other, as to each separate offense, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand that pleading no contest, you're giving up your right to have a trial?
Yes, Your Honor.
If you had a trial, you'd have the right to have an attorney represent you at that trial. And if you could not afford an attorney, the court would appoint one for you free of charge to do that. You understand that?
Yes, Your Honor.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. By her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility, the obligation to prove you guilty before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I talk about that burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to do that, I said guilty there, but no contest here. In order to try to do that, if we were going to have a trial, the prosecutor would bring witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading no contest, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request this court issue an order that we call a subpoena. And what a subpoena would do is it would force or make someone come to court to testify for you and answer your lawyer's questions if there was someone out there that wasn't willing to come in voluntarily or on their own. Do you understand that?
Yes, Your Honor.
And do you realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision. That's a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we did go to trial and you were found guilty of either of these charges, you would have the right to appeal or challenge that guilty finding to another court, a court that sits above me and reviews my decisions. Now, by pleading no contest here, you're still preserving your right to appeal any decisions this court has made up until this point, including the suppression hearing, decision on the suppression hearing that I'd made. I think it was last week. Yes, technically you can also appeal if I find you guilty based on the facts that are presented, you have a right to appeal that if you don't think those facts are sufficient to constitute someone being guilty of the offense. So you do have a right. The no contest plea preserves your right to appeal these issues that have previously been raised or brought to the court's attention. Do you understand that?
Yes, Your Honor.
Anything that's not been brought to the court's attention, you waive those rights. If there's some issues out there, you can't bring some issue up new to the Court of Appeal. It's already have to have been brought to this, raised to this court, and I would have to have ruled on it before you could do that. You understand that?
Yes, Your Honor.
Right. All right, well, do you have any questions at all regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading no contest. Any questions?
No, not at this moment.
You understand them all?
Yes, Your Honor.
Do you still want to plead no contest?
Yes, Your Honor.
Now, a no contest plea is not an admission of your guilt, but it's an admission of the truth of the facts that are alleged in the indictment in counts 1 and 2 that I just read to you. And plea or admission is not permitted to be used against you in any subsequent civil or criminal proceeding. You understand that?
Yes, Your Honor.
And also, as I just explained, it also does preserve your right to appeal the suppression ruling that was done in this court, as well as any. I don't think there were any other rulings, but if there were any other rulings that were made by the court, you have a right to appeal those as well. You understand that?
Yes, Your Honor.
Further, the effect of a no contest plea, aside from what I just told you, is that the court will hear what the facts are. The court will then make a determination whether those facts are sufficient to support a finding of guilt. If they are, I would find you guilty of the charges, and then we would proceed to sentencing. Now, we're not going to do sentencing today, but you would be sentenced as a result of being found guilty by the court. Do you understand that?
Yes, Your Honor.
Now, as far as potential sentencing goes, you're pleading no contest here to 2 charges. Count 1 with the methamphetamine is a felony of the 3rd degree. That is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, 30. So if I impose a prison term on that count, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months you'd have to serve for count 1. Do you understand that?
Yes, Your Honor.
Now, count 2 is a felony of the 5th degree. It's punishable by a possible term in prison of a minimum of 6 months, maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, since there's 2 charges here, if I impose a prison sentence, I'd impose it on each count. Then as the judge, I do have the discretion to run those prison terms either concurrent or consecutive. Concurrent means together, you serve them at the same time. Consecutive means one after the other. You understand the difference there?
Yes, Your Honor.
So in this case, if I impose the maximum sentence on each count, I'm required to make sure you understand what the maximum sentence could be. You're looking at in random consecutive, you're looking at a maximum prison term of 48 months or 4 years in prison. You understand that?
Yes, Your Honor.
Now, are you currently on probation or parole, PRC, and any type of supervision to any other courts or agencies?
I haven't been in any trouble since the last time I went to prison, Your Honor.
Okay. Any other charges pending against you right now anywhere else?
No charges.
If a prison sentence is imposed in this case upon your release from prison, you could be placed on what we call post-release control. We sometimes call that parole, PRC. It's a period of supervision you would be on after you served whatever the prison sentence was. And in this particular case, it could be up to 2 years. It's not mandatory. It's up to the parole authority to decide that. I don't have any control over that. But it could be up to 2 years. You understand that?
Yes, Your Honor.
And if you were ever put on post-release control and violated any of the conditions of your supervision, the parole authority could return you to prison or send you back to prison as punishment for not following the rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, Your Honor.
All right, now aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. Count 1, being a felony of the 3rd degree, requires that a mandatory fine of at least $5,000 be imposed, and you could be fined up to $10,000. Do you understand that?
Yes, Your Honor.
Now, if you file an affidavit of indigency, the court can consider that and waive that fine, but without that affidavit, I am required to impose it. I have no discretion in that regard. You understand that?
Yes, Your Honor.
Now, count 2 is not a mandatory fine, but you could be fined up to $2,500 on that count. Do you understand that?
Yes, Your Honor.
So together, there's a possible fine of up to $12,500. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay court costs or reimburse the county for any costs of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, Your Honor.
Drug charges also carry with it a possible license suspension. It's not mandatory, but the judge has discretion to suspend your license up to 5 years. Do you understand that?
Yes, Your Honor.
I'm forgetting something. Oh, the forfeiture, as I mentioned before. Any right, title, or interest you have in any of that property in the forfeiture specification will be forfeited in the state of Ohio. Do you understand that?
Yes. Yes. Yes, Your Honor.
All right, now a few moments ago I explained the possible prison sentence you face. I used the word possible. Prison is not mandatory with either of these charges. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you would automatically be put on probation? It means it would be considered by the court if that's what you were seeking. I'd look at all the information presented, and I would make the decision I thought was the right thing to do. Do you understand that?
Yes, Your Honor.
Now, even though you are eligible for community control sanctions or probation, I need to advise you that in count 1, there is a presumption that a prison term be imposed, which means the court has to impose a prison sentence unless the court's able to make certain findings at the time of sentencing which would overcome that presumption and permit me to put you on community control sanctions. Do you understand that?
I think so.
You have any questions about that? You seem hesitant there.
The presumption, as indicated, there's certain factors certain findings that need to be made in order to rebut that presumption.
Okay.
Okay.
So prison's not mandatory. I'm not required to impose prison, but there's a presumption that I have to impose prison unless I can make certain findings based on the facts of the case, facts on your personal circumstances that would allow me to overcome the presumption, rebut it, as the lawyer said, and impose probation.
Okay, I understand.
Okay.
Yes,
Any more questions about that?
No.
If I were to put you on community control sanctions, it could be up to 5 years, and as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve time in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, Your Honor.
Further, if you were put on community control sanctions, you never violate, and you ever violated any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I can impose more restrictive sanctions against you, including an order that you serve local time in the county jail. Or I could, at that point, terminate or end your probation and send you to prison then. And again, that could be 9, 12, 18, 24, 36 months on count 1, 6 to 12 months on count 2. It could be consecutive, so 48 months in prison, which also could be consecutive to any other sentence you may be serving for some other case, if something were to happen, or that you're being sentenced to at that time for some other case. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for the sentencing hearing, you'll have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor also does have a right to recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all regarding the potential penalties you face by entering a plea of no contest here today?
No, Your Honor.
You understand all the possible consequences?
Yes, sir.
Do you still want to enter a plea of no contest?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyer and have him review reports with you, discuss issues, answer questions?
Yes, Your Honor.
Are you satisfied with his advice and counsel?
Yes, Your Honor.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
None whatsoever, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering this, I said guilty again, are you entering this no contest plea freely and voluntarily?
Yes, Your Honor.
All right, then, Mr. Fursick, any questions for me at this point regarding anything we've just talked about, the rights you're giving up, the penalties you face, what you're pleading no contest to? Any questions at all?
Not at the moment, Your Honor.
You need any more time to speak with Mr. Lallo before we go forward with your plea?
No, I'm good, thank you.
All right, then what's going to happen at this point, the prosecutor is going to explain for me what she believes the facts would establish at a trial if we were to have a trial. I want you to listen to her because then I'll have a question for you about that, all right?
Okay, yes, Your Honor.
Ms. Bell.
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on October 16, 2025, Daniel Fursick was operating a motor vehicle in Paynesville, Lake County, Ohio. That vehicle was pulled over for a display of plates violation. The officer was investigating, and it was determined that the car was going to be impounded. The vehicle was searched. Suspected psilocybin and psilocin mushrooms were located. Those were sent to Lake County Crime Lab and confirmed to be psilocybin and psilocin mushrooms, a Schedule I drug, less than the bulk amount. Subsequent to finding those mushrooms, the defendant's person was searched and suspected methamphetamine was found. That methamphetamine was sent to the Lake County Crime Lab, confirmed to be methamphetamine, a Schedule II drug, exceeding the bulk amount but less than 5 times the bulk amount, and Mr. Fursick admitted that both of those drugs belonged to him. And for purposes of the forfeiture, syringes were also found in the vehicle. Thank you.
Thank you. So, Mr. Fursick, were you able to hear what the prosecutor just had to say regarding what she believes the facts would establish? And you know what the indictment says. I read that to you.
Yes, Your Honor.
In this case. So as to those facts and as to the allegations in the indictment, what is your plea at this time?
No contest, Your Honor.
I have with me at this time a document called a written plea of no contest and judgment entry. It sets forth everything I've just explained to you. Before I can accept your plea, I need to make sure you understand this document and you sign it here in court. Now, this is the paperwork I was referring to earlier. I know you had a chance to look this over before with your lawyer. I made one change to it, and that's on page 2, second paragraph, where it reads, I'm not under the influence of drugs or alcohol. I'm not taking any drugs or alcohol. In a 48-hour period preceding this hearing, I inserted the words, except for Depakote, Lexapro, Clonidine, Tylenol, methocarbamol, Nexium, and a laxative. So I added that in based on our conversation we had earlier. Otherwise, the paperwork is the exact same as you saw initially. My understanding is you did have a chance to go over this with your lawyer, is that correct?
Yes, Your Honor.
Mr. Lallo, is that accurate? Did you read this to your client, review it with him, answer his questions, if he had difficulty, assist him with that?
Yes, I did, Your Honor, and prior to this hearing, both Mr. Fursick and myself did sign or put our signatures on that document, along with Ms. Bell as well.
So when you went over it with Mr. Fursick, did he indicate an understanding of it to you?
He did, Your Honor.
Is that correct, sir?
Yes, Your Honor.
So you understand what this document says?
Yes.
Do you have any questions for me about anything in there?
No, Your Honor.
Your lawyer indicated that you signed the document. He witnessed you sign it. Is that in fact, did you sign it? I see there's a signature here. You signed it?
Yes, Your Honor.
Ms. Bell, you did witness that as well?
I did, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of no contest. Let the record reflect. The defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charges, the effect of the no contest plea, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, and based on the recitation of facts set forth by the state of Ohio, I find those facts are sufficient to establish the defendant's guilt in regards to counts 1 and 2, and I will find the defendant guilty of counts 1 and 2, specifically count 1, aggravated possession of drugs, felony to the third degree in violation of 292511 with the forfeiture specification, and count 2, aggravated possession of drugs, a felony of the fifth degree in violation of 292511 with the forfeiture specification. I will defer sentencing, order a pre-sentence report investigation, drug and alcohol evaluation. Did you want a psychological evaluation, Mr.?
Yes, sir.
And a psychological evaluation. And I think that's everything. Ms. Bell, is there anything else at this point?
Nothing further, Your Honor. Thank you.
Mr. Lallo?
No, Your Honor.
All right, thank you.
Okie dokie, friends. Once again, good morning. It's a nice Thursday here in Courtlandia. There's actually kind of an embarrassment of riches at the moment. There's a lot going on in a lot of courtrooms across the country. But I'm gonna stay in this building. Let's go back to Judge O'Donnell, new contestant there.
Is that what you want to do?
Yes, sir.
All right, so what exactly is the problem here?
To be honest, sir, what happened was...
Please be honest.
Yes, sir. I was on my way up here for probation, my normal weekly thing. Every Monday, I was doing the decision points, and my vehicle broke down on the side of the freeway. I took pictures of it. I had the vehicle towed. I sent pictures and receipts to my probation officer stating that my vehicle broke down. And as you know, I was coming from Akron at that point, and she pretty much told me that if I do not show up, I violate. That is
Who is that? Which officer?
Megan. And I sent her pictures and receipts. I mean, I didn't lie. I mean, my car, I don't have a car anymore. So I have no vehicle anymore because of that.
So what have you been doing for the better part of 9 months?
Been volunteering, been trying to do side jobs whenever I can, been helping out at the church as much as I can and the food bank, and to be honest, was just trying to get things settled in Akron. As you know, I originally was up here in Paynesville, and then due to this case a year ago, I lost everything. So I was just trying to rebuild a at least somewhat stable apartment, and then once again, I failed on probation, meaning I had a warrant, and with my job history, it's kind of hard for me to apply to any type of job because of the warrant, so I was unable to obtain work. So that's why I chose to turn myself in to get this resolved.
Where did you turn yourself in?
Down in Akron. Summit County, I was there for a week, and then I've been here for a week now.
All right, so where were you working?
I just was doing under the table side jobs, shoveling snow, doing sidewalks, clearing driveways, helping out whoever I could, helping people at church when needed, just whatever I could do.
Didn't you have an interview last July somewhere down there?
Yes.
What happened with that?
I had the interview, had a secondary interview, and then never got a call back. So just didn't work out. And then once I lost the vehicle, losing transportation is a big thing. So
So how did you think all this was gonna end?
By turning myself in.
Well, when you didn't show up, so was this July 28th you were on your way here?
I believe it was later than that, sir.
Okay, well, you didn't show up July 28th. Is there any notes from Megan that you have there, Kim?
I will pull that up and look, Your Honor.
Because
That little synopsis, Kim, has all of her notes.
Oh,
Yeah.
on that little piece of paper?
Mhm.
Okay, that'll be a little easier, I'll pull that up. So the last note that she has. No, oh, there we go. It's not showing what I need, but thank you, Jim. I'll have it in just a second.
my guess is that it wasn't July 28th where your car broke down and you called Megan and told her that and sent her pictures and she said, I don't care, get here, or a warrant's going out. That's not Megan.
I have it, Your Honor.
Go ahead.
I do have on 7/28, she said, Zachary called a tow place, $150 to get it back to Akron, can't get rides. Called the people he could. I told him to call me tomorrow afternoon and I would talk to Chief of Probation about this. He emailed me pics of what he says is the broken down car attached. But she still gave him a failure to report, and that was on 7/28/25. And then on 7/31/25, she staffed the failure to reports with Craig. If he does not come for this decision point, an office visit on Monday, we will violate. I called Zachary and told him this.
Yeah.
We discussed his job search. And then on 8/5, there was a failure to report yesterday. And then on 8/6 is when they decided we will file on the 2 failure to reports and failure to complete decision point.
At that point, I had no transportation, and that's what happened. I didn't have any contacts, there was no buses that ran from there, and I had no money, so that's why I failed.
So now what?
Well, I mean, where we left off last time is that I was close to finishing decision point, was that you were gonna allow me to transfer my probation to Akron so I'd be closer to where I was staying. But now that I've failed on decision point, I understand that's gonna be a problem. So now that I've made somewhat of a community, I do have some people at church that are willing to help me with rides and get where I need to be for probation and meetings and whatnot if need be. But in the end, I mean, my goal is where we left off last time, was decision points, transfer to Akron, and finish on my probation.
That was last time.
I understand that, sir.
Last time you were here, your history was that you were in trouble in Wisconsin.
Yes, sir, early 20s.
From 2010 through 2014. And then weren't in trouble at all until this.
Yes, sir, young and dumb, and I got myself cleaned up.
Okay, so so now you've created a mess for yourself that didn't exist last time you were here.
Yes, sir.
So what kind of drugs have you been doing in the last 9 months?
None.
Now, how do I know that?
Drug test me. Follow-up test me.
The idea is show up on Mondays and Megan drug test you.
Well, I never failed once that I was going.
And I, see, I just, you have put me in a position to not believe you when you say that.
Yeah, I understand.
Okay. Yes, sir.
Your Honor, I'm a pastor of a church in Akron, Goodyear Heights area, where Zach has been and his girlfriend have been volunteering for the last, I don't know, I would guess probably 3 months. And so that's how I've got to know Zach and Ashley. They just first came to get food from we have a very large distribution. I'll be quick. So anyway, that's how I got to know them a little bit, but then they switched from just coming to get food to coming and volunteering their time. And they were paying or having to pay for Lyft rides to get from their place so they could just come volunteer. They don't get paid. But I think that speaks to what they're trying to do as a couple. And so after I came to that realization, then we started making sure that we went and picked them up. So that it wasn't costing them to come volunteer to help us through the church. So I can vouch for that he is an extremely hard worker. He works his butt off when he's there. And I'm talking 3 or 4 or 5 hours at a time. It's obvious that he's made some bad decisions, but I believe with all my heart that he wants to, straighten out his life so that he and Ashley can move forward together. Obviously, the car issue is a huge issue, and the job is a huge issue. Granted, they're his fault. I have some friends in council in Akron. I know I don't understand how the felony part works, but I'm sure that I can talk to some folks and we can help find him a job. If we can get him closer to Akron, I'd be happy to personally make sure that he gets to his meetings. I believe in him enough that I'll be willing to do that. I'll do whatever it takes to help this young man as he's trying to get his life back together, if that is in your purview as possible.
All right, thank you. So are you telling me the reason you didn't get a job is because you had a warrant out for you?
No, that's not completely true. I mean, the first month and a half, getting down there, getting settled, learning the area, I applied to a few places. I procrastinated a little bit, to be honest. Then by the time I really got on it, trying to apply to places, I had a few interviews, had a few good leads, and then the car broke down and that was it. So, I mean, at this point, I just want to get back to work and just try my best. That's why I turned myself in. I'm not going to run from this. I made a mistake. I'm trying to do right by it.
Do you have a license?
Yes.
When did you get it?
I have a payment plan and mentor, so technically no. I just have to finish paying that ticket and my license is reinstated.
Okay, so when I ask you if you have a
license.
license.
Sorry.
You don't have
Sorry,
it.
yes. I just
How
have
much
one
do you
ticket.
owe Mentor?
I think it's only $140 left.
Okay. What kind of work are you gonna do?
I'm a certified CNC operator, certified welder. I've been a maintenance technician for the last 8 years. I worked at Weaver Meats, as we've talked about, and Alloy Precision Technologies mentor. I'm very versatile. I'm a 480 electrician certified. I can do anything. I'm quite smart.
Okay, then you should get about doing something.
Yeah, and that's...
Because from what you just told me, you've got the ability to make a lot of money.
I do.
At each of those individual things.
I know.
So get off your ass and do it.
I know, I'm screwed up.
Okay. How old are you now?
35.
Okay. Let's not revert to 25.
I know. That's why I'm, like I was telling the officer, I'm glad I never resorted back to drugs or anything stupid, at least, so. I'm not going to go backwards, I can only move forward.
I don't see many people come in here that that have certification as welders, that have the ability to operate the machines and to be an electrician.
Yeah.
Most of them don't have the ability to find their ass with both their hands, okay? So there's no excuse for you
I know.
of bouncing around.
Forgive me, friends, just a quick pause. It's a choose your own adventure time. So after this, Judge Tony Flores is doing a preliminary exam up in Lansing, and it looks like it'd be a little bit of a longer hearing, but there's body cam, and we rarely get to see body cam. So if that interests you, put a 1 in the chat, and if I see enough 1s, we'll go there after this. Anyways, sorry to interrupt, back to it.
Working under the table, avoiding responsibility, no excuse for you.
No. That's why I turned myself in. I didn't want to do it anymore.
Then you shouldn't do it anymore. So you spent a week in Summit
Yes, sir.
and a week here?
Yes, sir.
Do you want to waive his final hearing, Jim?
Your Honor, we would waive the final hearing and enter a plea of guilty to the violation.
Is that what you want to do?
Yes, sir.
What's your plea to these allegations?
Guilty, sir.
All right, I'll accept your guilty plea and find you guilty. All right, you're going to be continued on community control. Serve 14 days in jail. Credit for 14.
Excuse me, Your Honor.
Yeah.
We have 11.
11?
Yes.
So he's only been here for 4 days?
We have 2/9/26 to 2/19/26.
2/9,
Thursday to Thursday.
2/9. Did you say 2/19 to 2?
Yes, we have 2/9 to 2/19 as well.
All right, so 11 here, I guess. So, so 18 credit for 18.
Okay.
When you got did you get your dual diagnosis evaluation?
No.
Why not?
I was hoping to get a job to get insurance because I applied for, me and Megan talked about, I applied for emergency health care or something because I don't have health insurance. So she had me apply for that so I could get insurance before I got a job. But I never got approved for that insurance, I think, because I don't know.
Everybody gets approved for that insurance.
I'm not sure.
You ever had a mental health diagnosis before?
I don't believe so. I don't know what that is exactly, sir.
Any doctor ever tell you you got anxiety, depression, PTSD?
Oh, yes.
That's what he's referring to.
Yes. Yes, sir. Then yes.
Okay, so when was that?
The last time probably was about 2 years ago, and then I had a therapist that I met with weekly, and I got diagnosed with anxiety and depression. And then
Was there a course of treatment initiated after that?
just therapy.
Did
And
you
then
do
I was-
that?
Huh?
Did you do that?
Yeah, I've met with her weekly on a video chat through BetterHelp, and then when I lost my insurance, when I originally got arrested for this, I lost my insurance, and then I lost contact with Erica, which was my therapist. So if I get insurance, I would like to reach out to Erica again. I was with her for like 3 years.
Okay, I'm gonna keep you on community control. Like I said, 18 days, credit 18, no drugs or alcohol with screens. You're going to obtain and maintain full employment, and that means full employment to your potential. You're gonna get a valid license. You're gonna pay the costs and supervision fees. I'm gonna transfer your probation to Summit County. However, for the time being, until further notice, you're still gonna report here one time per month. And Kim, I don't know if that'll be to Craig or who, but I want to keep tabs on you because I don't necessarily trust Summit County.
Okay.
Okay. Because the bigger the county, the less they do, quite frankly.
Makes sense. Yeah, that jail was horrible.
So all jails are horrible. Is this
Well,
place,
that one was-
this place a peach over here?
Compared to there, sir, it was bad.
Well, you should stay out of places.
I don't want to go anywhere back here or there.
So if you get, when you get your job that provides you insurance and you want to see whatever her name was, what was her name?
Erica.
Erica, then you should see Erica.
Yes, sir.
I could force you to see Erica.
No, I enjoy her.
But if I force you to see Erica, then you'll go to it, you'll probably stare at the wall, and you ain't gonna get nothing out of it. So if you think that helps you, then you should help yourself, because you should really help yourself.
Yeah, I liked her. It took me a long time to find a therapist that I actually could open up to and like enjoyed talking to, so.
Now, if you don't comply with these terms, then what happens?
Back here again.
Right.
I don't want to do that.
All right, anything else, Mr. Matthews?
No, you're right.
Kim, anything else?
Yes, I have
Okay.
two questions.
Okay.
Even though you're allowing the transfer to Summit County, you want him to report here still once a month?
Right.
Wow. He's-
Right.
Okay. And another question is.
And the answer can't come back from those on high that can't be done, because it is
Okay.
going to be done.
Okay. And I found something else, Judge, so he does not have 18 days, he has 14 days back.
All right, 14.
Okay, thank you.
And then, when, the first time you come back here, I would assume in about a month, you're going to, you're gonna have written down to give to your probation officer exactly the steps that need to be taken to get the license.
Okay.
Now, you got a month, maybe it'll be taken care of if it's as simple as you say.
Yes.
Before then. If not, you're gonna put in writing all the details.
What I have to do. Understand, sir.
So you should figure out how to go about that, because you're a bright guy.
I can do it.
Nothing else?
Just as I say that, there's like a brief pause. But it looks like overall it's better. If you see anything different, let me know. So let's go to Lansing, Michigan. This is Tony Flores. There was enough ones in the chat to justify this. It's probably about a 40-minute hearing. I'm not sure what it's about, other than it looks like there's a significant amount of body cam footage that's used. And I believe this is a preliminary exam. So let's check it out and see what's going on.
Well, on behalf of the people,
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly, on behalf of the defendant Charles Withers, who is to my right.
And sir, you are Charles Withers, is that correct?
Yes, sir.
Okay, this is the time set for preliminary examination. It's my understanding a preliminary examination is going to be held today. Is there anything to come to the court's attention before we go forward with the preliminary examination, Ms. Fortunigo?
No, Your Honor, there's only one witness. I anticipate that the people will only be calling one witness, Officer Vanderwerf, so I don't believe a sequestration order is necessary.
All right, I'll invoke the sequestration order if I hear from counsel that somebody comes in and see somebody on the stand that they shouldn't be seeing on the stand. We have the one officer who's present in the courtroom. Anything from the defense, Ms. Donnelly?
No, Your Honor.
All right, thank you. All right, for the preliminary examination 25-02459, Ms. Fortuna Gill, the people may call their first witness.
Thank you, Your Honor. The people would call Zachariah Vanderwerf.
All right, Mr. Vanderwerf, Officer Vanderwerf, you can come up here. You can stand right in front of me and state and spell your first name and your last name for the record.
Yes, it's Officer Zachariah Vanderwerf.
All right, and if you could spell them.
Yep. Spelled Zachariah. Last name is Vander, capital WERF.
Okay, please raise your right hand, sir. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, go and have a seat. The microphone, as you know, goes right to the court recorder's ears, so please project as best you can. And Ms. Fortuna Gill, when you're ready.
Thank you, Your Honor. Officer Vanderwerf, can you tell me a bit about what you do for a living?
Yes, I'm a police officer in the city of Lansing.
And how long have you been a police officer for the city of Lansing?
It'll be 9 years at the end of February here.
Okay. And were you employed as a police officer in the city of Lansing on August 13th of 2025?
Yes.
And what were your job duties that day?
So I was working road patrol, but I was responding to 911 calls that day.
Okay, and do you recall responding to a call at East Saginaw Street in North Pennsylvania?
Yes.
Okay, and is that in the city of Lansing?
Yes, it is.
County of Ingham?
Yes.
State of Michigan?
Yes.
And can you tell me what was going on when you arrived at East Saginaw Street in North Pennsylvania?
Yeah, so we received a call. Someone had reported that a male was pushing a female off the bus, so it was a possible domestic.
Okay, and what is it that you actually saw when you arrived?
So I drove through the intersection of Saginaw and Pennsylvania. I hadn't seen anything at that time, and I continued down the street until I made it close to, like, I believe it was Saginaw, Maryland, roughly right around that area in front of like Lansing Catholic. And what was described is that it was supposed to be a black male wearing an orange shirt and a white female with him. And then that's who I observed walking down the sidewalk.
Okay, so these people that you observed walking down the sidewalk, they matched the description that dispatch had given you?
Yes.
Okay, and so what did you do next?
So I activated my lights on my police vehicle to just signal that I was a police officer. And I rolled down the window and asked if I could speak to both of them.
Okay, and when you say you activated your lights, were you in a fully marked patrol vehicle?
Yes, I was.
And what were you wearing that day?
I was in full police uniform that day.
Okay, and how is it that the two individuals reacted when you asked to speak with them?
So Mr. Withers actually stopped to speak with me, and then the female tried to continue to walk away. So at that time, I exited my vehicle and asked, I called out to her and asked if I could speak to her as well.
Okay, and you referred to Mr. Withers. Was that the male that you had seen?
Yes.
Okay, and would you recognize him if you saw him here today?
Yes,
Do you see him here today?
I do see him.
Can you point him out by describing an article of clothing he's wearing for me?
Yes, he's wearing the black hoodie over there.
Your Honor, at this time, I would like the record to reflect that Officer Vanderwerf has identified the defendant as Mr. Withers.
Any objection to the witnesses identifying the defendant for purposes of prelim, Ms. Donnelly?
No.
Okay, well, for purposes of prelim, the witnesses identified the defendant and you may proceed.
Thank you. So what happened next with your interaction?
So I was kind of just waiting for my partner so he could kind of get them separated, because typically during domestic assaults, like, someone will not, or if the female or male, whoever was the victim, won't speak to you unless you're separated from them. So kind of waited for my partner to get there so I could separate the two.
Okay, and that's standard procedure in these sort of cases?
Yes.
Okay, and when they were separated, who is it that you had an interaction with?
So I ended up speaking with the female.
Okay, and what occurred after your conversation with the female?
So when I was speaking with her, she had mentioned Mr. Withers' name, which was Charles Withers, Charles Irvin Withers.
Okay.
And then I had overheard when Officer Wilson was speaking to him that he gave different names.
Okay, so and you heard that with your own ears?
Yes.
Okay, and what happened next?
So at that point, Officer Wilson went to run his name through lean. And then at that point, I stayed with Mr. Withers until he could run his name. And then during that interaction, I had Mr. Withers remain seated because I believed he lied about his name. So typically, you know, if people try to stand up or not comply with your orders, they might try to run or fight, whatever it may be, if they realize that you recognize that they're lying about their name. So.
Okay, so what name, sorry, I didn't mean to cut you off.
Yeah, go ahead.
What name is it? Do you recall what name Mr. Withers gave you?
I don't recall. I think it was Eric Miller, but I'm not sure. If that was
Okay.
the correct name.
But nothing close to Charles Withers?
No.
Withers? Okay.
No.
And, or I apologize, he didn't actually give you that name, he gave your partner that name, but
Yes.
you heard that with your own ears?
Yes.
Okay. And the name that was getting ran through lean, is that the Eric Miller name or the Charles Withers name?
I believe you'd have to ask Officer Wilson, but I believe he was running Eric
Okay.
Miller's name through.
Okay. And so while you're sitting with Mr. Withers, well, what happens then?
Well, during that interaction, after I told him to remain seated, he tried to stand up a couple of times, saying that he needed to use the bathroom.
Okay.
But there was no restroom that was close by, and we're right in front of the school, so it's not like I can let him just use the bathroom there.
Sure.
So at that time, we're just kind of waiting, and I have him remain seated again. He's tried to stand up a couple of times. So then I get over the radio to tell Officer Wilson the name that he should try to run. Well, he's in earshot of me saying that, and then at that point, he stands up again after I told him multiple times not to do that.
Okay, so he disobeyed your command several times?
Yes.
Okay, and when he was standing up, when you had ordered him to sit down, what is it that you were fearful of in that moment?
His flight. I was afraid he was gonna try to run.
Okay. I have no further questions for this witness at this time.
Cross-examination, Ms. Donnelly.
Good morning, Officer Vanderwerf.
Good morning.
All right, and your testimony here today was when you got the call and were given a description. The only ones you saw matching the description were Mr. Withers and the female he was with.
Yes.
Did you were you wearing your body worn camera that day?
I was.
All right, and was it working?
Yes.
All right, and would you recognize it if you saw it?
Yes, my body cam. Yes.
All right. So, Your Honor, can I use the cord to plug in my computer?
Yeah, and so you plan to move for the admission of the videotape for the body cam?
Yes.
All right. Any objection to, and I'm assuming foundation will be laid because you'll show them the initial scene. So with that understanding, the witness can I at least identify maybe the first 3 or 4 seconds to make sure that that's from the body cam, and then I'll entertain a motion to admit.
With that understanding, Your Honor, there would be no objection.
Okay, and is there any objection to the body cam coming in?
No objection, Your Honor.
All right, so there's no objection pursuant to stipulation. I just want to make sure we're all seeing the same thing, okay? All right, so so pursuant to stipulation, People's Exhibit 1, or it'll be Defense Exhibit 1 will be admitted once we get it all hooked up. And that'll be the body cam from Officer is it Vanderwerf? Vanderwerf.
And Your Honor, I'm not intending to play, the whole video is an hour and 15 minutes. I'm not intending to play it all,
right.
so I'm just gonna enter a partial, and obviously the prosecutor for completeness if they want to. And they can. All right. Okay, Officer Vanderwerf, do you recognize this?
As of right now, no, but I would assume this is me in the car.
Right, and
yes.
it's labeled August 13th, so that would be around the time frame. Is
Yes.
that- Okay.
Yes, correct.
All right. But at any point, is this something that looks to be altered or not what it was?
Hey, can I talk to you real quick?
So you recognize that?
Yeah. That's my
Okay.
voice.
All right, so we're, with that, Your Honor, I will, I just have one question, one additional question to establish foundation. Officer Vanderwerf, that, when you just heard you speak, is that what you said when you were talking about your interaction initially with the couple that you had seen?
Yes.
Okay, so this appears to be the same interaction you and I were speaking about earlier.
Yes.
Great, thank you. I have no objection, Your Honor.
All right, motion to admit People's Exhibit, its Defense Exhibit 1 would be admitted pursuant to stipulations. So Defense Exhibit 1 is admitted into evidence. And then if you have any objection to what we're seeing, I'll entertain the objection then, because I don't know how much we're showing, but you can go from there. And we have missed some. There have been about, I'd say, 20 seconds that led up to what we're looking at. So Ms. Donnelly, when you're ready.
I'm gonna start the video at 8 minutes and 29 seconds
right.
into it. So as the video shows, it's about August 13th, 2025, about 4:58 p.m. This is the point at which Officer Vanderwerf says that after, once he's talked to the female, what happens with then Mr. Withers. So that's where I'm starting.
Okay.
All right.
I'm with you. Like he's the only dude wearing an orange shirt. Like I ain't come across nobody else wearing an orange shirt. All right. You mind just hanging out here for a second? I'll be right back, okay? Yes, I can. Absolutely.
Yeah, I don't have anything coming back for him. Everything that I'm getting back is more so for email and that variation.
Okay, thank you. What's up? Yeah, I'll talk to you about it. You said nothing came back on him? No. Did you give him the right name?
Yes, I did.
You did? What's the name that you gave him?
Eric.
Eric?
Yeah.
Eric what?
Miller.
Miller?
Yeah.
You don't have any ID on you somewhere?
No, I don't, sir.
Where's it at?
I just ain't had none, man. Like, I've been fucked up for the last couple of years.
How long has it been since you've had ID? 4 years? But you had like a driver's license or I have Michigan ID?
I ain't had no driver's license.
So a Michigan ID?
I had more like a 308 ID.
Oh. Have you always lived in the state of Michigan? Yeah.
Yeah, like, man, don't be giving me no trouble and no shit like that.
Yeah, so in talking to her, basically, she said that he pushed her off the bus today. I could call the witness and see, but she said she's afraid and she doesn't want to be around him. Yeah, she got some scratch marks on the back of her neck. She tried to walk away and he grabbed her and scratched. I mean, if it's case, you guys do that, yeah, I'm actually. Yeah. 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 Hey, do you want to press charges against him for that assault today?
I'm just gonna pause it because I have a question, Officer Vanderwerf. So I'm pausing it at the time on stamp is 5:01 and 30 seconds p.m. Had you have you gotten her to tell you what Mr. Withers' name was yet by this point? Do you remember?
I don't remember.
I'll just keep playing.
What's that? No, you sure? Why? What's his name?
Charles Irwin Withers.
Oh.
I'll pause right there at timestamp says 5:01 and 58 seconds. Mr. Vanderwerf, at that moment, did you actually recognize the name?
Yes.
Okay, all right.
What's your date of birth?
12/16/76.
12/16/76.
Yeah.
Why do you look so familiar to me?
No.
Where were you staying down on the south side?
Are you good for a second?
You've never stayed on the south side? You never stayed over by Jolly and Penn? I'm pretty sure you did. It wasn't you? What's the name you gave him? Eric what?
No.
Miller? You didn't used to live by Penn and Jolly. Not right now, no.
I got to go back here.
Yeah, I understand what you're saying.
I got you got motherfuckers bad, man.
Yeah.
Right here.
I'm just trying to place it. I do remember speaking to you before. Just walking around. You know what? I think I remember where I know you from.
And we're not down there by the probably carried by Larkin.
Nope. No. I know you from Jolly and Pennsylvania. That's what it is. You came back to some house that the maintenance guy was in over there. The apartments down there. You know what I'm talking about? What was your name? It wasn't Eric. What was your name?
I hang out down by Larkin. I don't miss it.
No, I'm almost positive that was you down there. I'm almost positive. I just can't remember your name. I think you're lying about your name. What was it? It wasn't you, huh? You better remember it.
I never even been out on the south side in that area. Wherever you're talking about. I go down here by the Larkin.
pause it just momentarily because you know, there's a lull. It's at 5:06 and 22 seconds. Officer Vanderwerf, are you waiting for Officer Wilson to be running the lien information?
Yes.
Okay.
Correct.
Just making sure.
Yeah, I'm telling you, you can't use it right now. You know what? I think I remember what it is. Charles? That's your name? It's not Charles? Huh. Hey, Jessica, if you want to go sit in the shade, you can sit in the shade.
Sit in the shade too.
No, you can stay right here. I think you're lying about your name. I think your name's Charles. Uh-huh. That's what's coming back to my memory right now. I'm guaranteed that was you that was down there.
It might be somebody that look just like me. Can I please?
Nah, sit down.
Hey, can I please?
No,
use the
don't do
bathroom?
that.
No,
Sit back down.
okay, I
Sit
sat
back
down on my own.
Sit
sir.
down.
I sat down
Sit
on
down.
my own.
You
sir.
stay down there. Don't you try to get up again.
I just got to use the bathroom.
I understand what you're saying. I understand what you're saying, but I want you staying down there. Because I think you're lying about your name right now.
No, I'm not lying, bro. Can I please
Uh-huh.
use the bathroom right
No, you cannot. Not unless you want to charge. Okay. $22 to K9.
bag, sir. I promise you. I got you can couple me up, sir. I got to use the bag.
I think it's Charles
Please,
Irvin
sir.
Withers.
Please, sir. I got to use
No.
the bathroom.
No.
Come
No.
on, man.
Don't do that, bro. Don't do that. Don't do that shit.
Bro, I got to use the bathroom, bro.
I told you not. I told you not to do that. Okay? Because because you stood up. I told you not to. You're not gonna try to run.
I'm sorry, bro. I'm not gonna win. I got to use the bathroom, man. I got to use the bathroom, man. I told you can hook me up, bro. I gotta use it, sir. I'm gonna use it on myself.
I think that you testified, I'm ending it at the video at the timestamp on the date is August 13, 2025 at 5:09 p.m. and 38 seconds. The video itself ended at 17 minutes and 54 seconds into it. Officer Vanderwerf, you testified today that he resisted because you ordered him to stay seated and he disobeyed that order, correct?
Yes.
And in your video, he was telling you that he had to use the bathroom, right?
Yes.
Okay. And you said that you wouldn't allow him to use the bathroom because there wasn't any nearby bathrooms.
Correct.
Okay. And the implication being if he needed to relieve himself, he would be exposing himself in this getting a crime.
Yes.
Okay.
Correct. Yeah, because there was kids that were playing like tennis on the court just on the other side of those trees there too.
Okay. But at no point in that video, did he, did you see, did he say that he, was going to run, right?
No, he did not say that.
Your Honor, I have no further questions.
All right, redirect Ms. Fortuna Gill.
Briefly, Your Honor, Officer Vanderwerf, in the video, when you, when Mr. Withers stands up, is that the second or third time? Do you recall that he stands up?
I believe this is the second time that he stands up.
Okay, but he did stand up a time before that.
Yes,
And your response to that was what?
to have him sit back down.
Okay, and you explained to him that he was not to stand back up again until you had all the information.
Yes.
Okay, and when he stands up the second time and you proceed to place him under arrest, is that correct?
Yes. So when I went to grab him that time, he did pull his arm away.
Okay, that was my question. Was there any further resisting when you went to place him under arrest?
Yes.
Okay, thank you. I just wanted clarification. The video, it's kind of hard to tell exactly what's going on. Thank you. No further questions for this witness, Your Honor.
All right, any additional cross-examination, Ms. Donnelly?
No.
Ms. Fortuna Gill, may this witness be excused?
He may, Your Honor.
Thank you for your appearance today. You're excused, sir.
Thank you, Judge.
Any further witnesses today, Ms. Fortuna Gill?
No, Your Honor.
Do the people rest?
Yes, Your Honor.
All right, any witnesses today from the defense, Ms. Donnelly?
You didn't even really ask no questions that I wanted you to ask. Like, when was I under custody? Like,
Sir, Ms. Donnelly, do you plan on calling any witnesses today?
no.
No, Your Honor.
All right. Motion for bind over, Ms. Donnelly. Or Ms. Fortuna.
Okay, no, that's okay. Thank you, Your Honor. Today, Mr. Withers is charged with assaulting, resisting, or obstructing a police officer or person performing duties. We heard testimony from one officer today, Officer Zachariah Vanderwerf with the Lansing Police Department. He testified that on August 13th of 2025, he was working and dispatched to East Saginaw Street in North Pennsylvania for what was a potential domestic situation. He testified that this was in the city of Lansing, County of Ingham, State of Michigan, giving this court the proper jurisdiction. Additionally, Officer Vanderwerf was able to identify the defendant as Charles Withers, the individual whom he interacted with on August 13th date. To be charged with an R&O, first, the people must prove that the defendant assaulted, battered, wounded, resisted, obstructed, opposed, or endangered Mr. Zachariah Vanderwerf, who is a police officer with Lansing Police Department. We did hear testimony as well as watch body camera footage today that Mr. Withers gave Officer Vanderwerf the incorrect name, or his partner the incorrect name. I believe both of them, he gave them a false name. Then continued to stand up when instructed to sit down. Officer Vanderwerf did testify that he was fearful of Mr. Withers fleeing, and that Mr. Withers was indicating that he did need to use the restroom. However, there was no appropriate place for that to occur at this time, and that Mr. Withers needed to remain seating until the police officers had all of the information. And part of the reason why those police officers did not have the right information is because Mr. Withers refused to give it to them. Additionally, when Mr. Withers did stand up that second time, and Officer Vanderwerf was under the impression that he may try to flee, he was tackled and arrested at that time. When Officer Vanderwerf was arresting Mr. Withers, Mr. Withers continued to try to pull away from Officer Vanderwerf. We have heard all that testimony today from the officer, as well as saw the body camera footage. The people would ask for bind over on this count. Thank you.
Right. Response to motion for bind over, Ms. Donnelly.
Thank you, Your Honor. As stated by the prosecutor, it is their burden to show probable cause that Mr. Withers has committed the offense of resisting and obstructing an officer. The jury instructions requires that at trial, they prove beyond a reasonable doubt that there was a knowing failure to comply with a lawful order. So they just have to establish that by probable cause today. The issues the defense would like the court to consider is the fact that after viewing the officer's body worn camera, the incident, how it transpired happened very quickly, and as was evidenced on the video, Mr. Withers was very adamant that the reason why he was having difficulty sitting down was because he needed to use the bathroom, and he even offered the officers to handcuff him so that they knew that he wasn't fleeing. The officer, in his discretion, forced Mr. Withers to remain seated while Mr. Withers was in that uncomfortable position. So Your Honor, they have to, their burden is establishing probable cause that he knowingly failed to comply with a lawful command. As we can see on the video, it all happened rather quickly. Him standing up, the officer grabbing him, tackling him to the ground, and then both officers handcuffing him. Again, there has to be probable cause to establish that he knowingly failed to comply with their lawful commands. And we ask this court to consider dismissing it for failure to meet that burden. Thank you, Your Honor.
Thank you, Ms. Donnelly. Any response, Ms. Fortunigo?
No, Your Honor, I stand on my previous argument.
All right. The motion for bind over, the standard for preliminary examination is probable cause. Probable cause being the second lowest standard in criminal law, reasonable suspicion being a lower standard. I do find that location, venue, and date have been made at that this did occur on Saginaw Street, North Pennsylvania, in the city of Lansing. We got to see that as People's Exhibit, Defense Exhibit number 1. There was also I saw that, and then I saw the actual interaction with Officer Vanderwerf, who testified, was subject to cross-examination. We saw his body cam. So the decisions made on the witness and on the body cam. So location, venue, and the date of August 13, 2025 have all been established. Mr. Withers was identified as the person being in the video. And so ID has been made as Mr. Withers being in the court. So location, venue, ID, and date have been made. And then we have the offense elements. It does appear that, at least from Mr. Withers' perspective, he indicated he needed to go to the bathroom. But there has to be some investigation based on the name he gave them. And the investigation shows that he gave the name of Eric Miller initially. He did not come with his actual name. And so they're running his actual name to try to find out who they have in front of them. That was part of the investigation, which started out as a domestic violence investigation. And that's why Mr. Withers was stopped along with the female companion. I find that Mr. Withers, so there are issues in credibility to go to the trier fact, but at a probable cause level, the elements have been met on count 1 as resisting and obstructing an officer that on August 13, 2025 at East Saginaw Street, North Pennsylvania, in the city of Lansing, the defendant I didn't see an assault, batter, wound. I did see resisting. I did see some opposing and certainly endangering officers. Zachariah Vanderwerf, a police officer, he was marked. They were both marked as police officers, and they were subject to, the vehicles were also marked. The defendant knew or had reason of performing his or her duties. We had testimony from Officer Vanderwerf that he had indicated 2 commands for the defendant to sit down, and the defendant did not sit down. And the defendant was indicating he had to go to the bathroom. But there was an investigation on the prior name that was given to the officers, which was Eric Miller, which is not the correct name. And so they were looking to find the correct name. So these are all credibility issues that may go to the trier fact. But I find at a probable cause level that location, offense, venue, ID, and date have been made, and I will bind over on count 1. The habitual 4th offender notice also goes along with the count 1. And so this is bound over as charged. I will indicate the examination was held on today's date, which is February 19th, 2026. And there's probable cause to determine that count 1 has been committed. The habitual offender will follow. I have bond set at 2,000 PR, which was the original bond. And then I have a note on the file. So we got to clear this up that it was modified to 2,000 cash surety on February 2nd, 2026. This goes back to August 2025. So if we can clarify that, it says 2,000 PR bond, but the magistrate indicated 2,000 cash surety. What's your understanding of bond, Ms. Donnelly?
Your Honor, because there was a failure to appear, it's my understanding, yes, he posted a bond when it was a PR bond originally, and then it became a cash surety that he posted.
Okay, so he's 2,000 cash surety would be the correct amount of bond at this time. He did post a bond.
Yes.
Okay. All right. So I'm going to take off the PR bond. It is a 2,000 cash surety has been posted at this time. Is that a fair statement, Ms. Fortuna Gill? That's my reading of it. I just wanted to confirm that. There's previous fail to appears, and then the bond was set at 2,000 cash surety. A bond was posted, and then so it's not 2,000 PR anymore, as indicated by the bind over documentation. Is that your understanding, Ms. Fortuna Gill?
That is my understanding.
All right. So your time in district court, sir, is done. You're off to circuit court where you get your next date of appearance in circuit court from your attorney, Ms. Donnelly. Anything else before I sign the bind over documentation, Ms. Fortuna Gill?
Not for the people.
Ms. Donnelly.
Not for defense.
All right. I'm going to sign the bind over documentation, and bond is imposed. You'll get your next date of appearance from Ms. Donnelly. Thank you for your appearance today.
I gotta sign. All right.
So I think that was interesting to watch, and it's always good to see body cam when we can. But I am not sure exactly what that defense attorney was trying to achieve there. By showing all of that, I don't see any way that would have stopped probable cause from being found. I don't see any way that it helped that defendant. Now, if you see it differently, please tell me in the chat, because I'm curious. Maybe I'm missing something, but I don't see what the purpose of that was from a helping your client perspective. Maybe you do. Note for fourth hour today, we will probably do more court. Going forward, I told you before that the fourth hour is going to kind of be a work in progress as we figure it out. Mrs. TCF and I are actually working on kind of a scripted plan for how to handle that fourth hour based on the things that we've learned so far. But for now, until we finalize that, the fourth hour will generally be more court unless there's something going on out in Courtlandia that it's worth talking about, or a case that we see during the live show that's worth having more discussion on, something like that, just so we're all on the same page for now. But let's move forward. Go to Texas, and keeping with our promise of 9 to 11% more, Judge Boyd, let's go there.
Judge, I have to insert a appeal again.
All right, thank you.
One more thing. Not lying. We went over with the judge. Would you please?
All right, the court is calling 2025 CR 010368, State versus Devin Grisham. Can I have parties announced?
State Christopher Simpson for the defense.
And are you Mr. Grisham?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Devin Roy Grisham who's placed on deferred adjudication in 2025 CR 010368 for the offense of theft of property less than $2,500 with 2 or more previous convictions on October 7, 2025 for a period of 2 years? Is that you?
Yes, ma'am, it is.
All right, state.
Judge, be proceeding on a. Judge, be proceeding on violation condition number 1, specifically that on or about the 8th day of January 2026 in Fairfield, Texas, the defendant, Devin Roy Grisham, committed the offense of theft of property in violation of condition number 1.
Do you plead to that true or not true?
True. Judge, the recommended on.
Are you pleading on that? All right, any objection to the state's waivers?
No objections, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number one?
Yes, ma'am.
Court will find violation of condition number one true. Is there a proposed agreement?
There's a proposed agreement is to revoke the defendant, place them in the state jail for 8 months, and the state will be TICing cause number 2026 CR 001815.
All right, and is that a theft case?
It is,
All right.
and that is our agreement, Judge.
So the question becomes, why should I follow the agreement that y'all are saying y'all reached? Because he's on deferred for a theft case. And it was enhanced to a felony because he has previous theft. And now he's back and he has pled true to another theft case. Why shouldn't he receive 2 years? What's going on? Why is he committing thefts?
May I speak, Ron?
All right, Jonah, you want him to testify?
Mr.
right.
Yes, Mr. Commissioner would like to speak, sir.
You want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Devin Grisham, ma'am.
All right, so why is this happening?
Well, I was having I was homeless, ma'am, so I was, it doesn't give me the right to, to take anything, it's not mine, but I was having a hard time with that, so I was trying to just get money to be able to get a room and not be on the street.
Why not Haven for Hope? Does Haven for Hope charge?
We had him check into that, Judge. That's what I actually, 2 days ago, ma'am, I just got approved to.
But no, that was 2 days ago. This offense is the offense that you pled true to was January 8, 2026. So you're telling me that you were homeless and that's why you were stealing. So why didn't you do Haven for Hope before January 8, 2026?
I should.
And did you contact probation and tell them you were having issues?
Yes, ma'am. I was checking.
No. Did you contact probation and tell them you were having issues with being homeless and what was going on in your life? Because they're here to help you.
No.
Did you do anything on probation?
Yes, ma'am.
What did you do?
Him, I had gotten started with, he got me set up with classes. We had just, me and my probation officer, I'd just seen him like a day before I got arrested. And started, to get things set up.
But I mean, he's been on probation since October 7th, 2025. What does he mean?
Judge, I believe we tried to get him into the felony drug court. They found that he didn't meet the criteria. And so I believe he'd been held after the screening on that. I believe that would have been the most successful route for him.
Any questions?
No questions, Judge.
Probation?
Yes, sir.
What are you all recommending?
I believe it was ISF.
Recommended listed on the court summary indicates upon disposition of the pending case of main conditions for local ISF, followed by ISP. He was not accepted into felony drug court, Judge, due to him not meeting the criteria for substance dependence. Probation met with him one time, and then he was rearrested 3 months after being granted for this same offense.
Okay. All right, I'm going to give you a choice. These are your only two choices. There are no other choices. Do you understand?
Yes, ma'am.
First choice, I will revoke you. I'll sentence you to 1 year at the state jail facility. Second choice, I will continue you. We'll try to work with you. I say we, probation will, but you're going to be going to ISF.
That's that 90-day program we just.
Well, here's the thing. You know yourself better than I do, better than your attorney does, better than probation does. If you want help, I will continue you. If you don't, I'll sentence you to 1 year in the state jail facility. With 1 year in the state jail facility, you receive credit for any time that you've been in custody on this case. Otherwise, you're going to be transferred to ISF. And then hopefully, you'll be better able to communicate with probation. So which do you prefer?
I'm looking right now.
Looking.
Your state, gentlemen.
Okay. Are you waiving your right to appeal?
Yes.
All right, the court then will revoke, find you guilty, sentence you to 1 year in the state jail facility, give you credit for any time served. I'll request the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. I have no jurisdiction to force them to place you in the program. You'll have to request it as well, but it should help you with whatever issues you may be experiencing. There's to be no contact with Quick Trip or Walmart. And no unsupervised contact with minors. Taking consideration 2026 CR 001815. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, please.
Because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, please.
All right, we can go off the record. Here's the thing. You're gonna have to start making better choices. If everybody who didn't have money stole, where would we be as a society, right? There are plenty of places that can help you. Excuse me. There are plenty of places that can help you. There's Haven for Hope. There's the Salvation Army. If you can't find some place when you're released, if I'm still here, you come back here and I will pick up the phone to call somebody to help you and give you access to programs, all right? All right, good luck to you, okay?
Thank you, Judge.
You're welcome.
Yes, sir. Come on this way.
Michael Groff in the chat. He takes the jail time. Man, I'll never get over that. I agree with you, but I guess there's a little bit of know thyself. I mean, if you know you're not going to make it through whatever the alternative is, then I guess you might as well just take the jail time. It's sad, though, isn't it, that people get to that state? But some do, I guess. I mean, we see it here enough. Let's go to Michigan. This is Judge McNally. It's from today, a little bit in the Wayback Machine, though. This is probably from about an hour ago.
All right. People against Charles Anthony Faust.
Right around.
26F245377.
For the record, James Sparrow, B57197 on behalf of Mr. Faust, since the time and date set for trial goes.
Good morning. Your name, sir? Where was he? Why didn't he show up?
Your Honor, what happened is, as you see from the nature of the charge, his driving while license expired. He had a friend that was willing to pick him up. His friend called him, told him he was running late. My client did call the court right around the time he was supposed to be here. And, the court basically told him, that they would either get back to him or give him another date. He called me later that day. I saw that this was in the system and then he retained me.
All right. So does he stand mute, wait formal reading?
Yes, Your Honor.
Flat Rock's here today, aren't they, Heather?
Yes, I've already talked about her and we're just waiting on the file to go back in.
Okay. I'll enter a not guilty plea. $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We'll give you that. Take to the prosecutor and then let me know when you're ready.
We'll see in a few.
Thank you. Higgins. Ashley Michelle Higgins, 26B82699A and B and C.
This is the point.
Your name? You have an animal violation, vicious dog. You have 2 civil infractions, dog roaming at large, and license, no dog license. You have the right to an attorney. If you would like one, I will give you one. Do you want an attorney?
Yeah.
All right. So I'll arraign you and then I would send you to the prosecutor, okay? So you have 1 misdemeanor, vicious act. It is alleged that on January 18 of 26 that you had a dog that was on Racco near Relda in Brownstown. and it attacked another dog, that is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all of those penalties. Do you understand that? Did you sign, read, and understand this advice of rights form? If you plead guilty, you will be giving up all those rights on the advice of rights, and there will not be a hearing or a trial of any kind. Do you understand that? You got to keep your voice up.
Yeah.
All right. You still have the 2 civil infractions, no dog license and dog at large.
And I did get the license for the dogs.
Okay. So I'm going to enter a plea of denial on those. What kind of dog is this? Okay, you got to keep your voice up. Okay. All right.
And my neighbor, I don't know if it's you that I speak with, but my neighbor did say that she was trying to drop the charges. So she did write a letter to you, and I think was gonna talk to the prosecutor about it.
I don't have anything to do with that. Your dog is to be in a fenced-in yard or on a leash, equipped with a muzzle, and accompanied by a suitable adult. Do you understand that? Or inside your residence. Okay?
Yeah.
Also, again, you cannot leave the state without consent or violate a law, and you must appear in court as directed. You go out in the hall, he's taking the file to the prosecutor, you sign in out there, and the prosecutor will call you, okay? Good luck. Either way, you're coming back in front of me. Nevin Todd Janov, 26R514412. Your name, sir? You're charged with super drunk, and you have the right to a lawyer. You want a lawyer?
Yes.
All right, John set him up with an attorney. You can go out in the hallway and we will set you up. Okay?
Yes, sir.
Either way, you're coming back in front of me. Thank you. Emma Swade? Two 6R514500. Good morning, ma'am. Your name?
Good morning, Emma Sweat.
Okay, so you met with the department rep, the Officer Hirschberger, it looks like, and you two agreed that you would plead responsible for impeding traffic with the speeding to be dismissed, true? To that charge of impeding, responsible or not responsible?
Responsible.
Plea is accepted, speeds dismissed, 150 is your total. Cash, you're into the hall to your right and you're all set.
Thank you.
Good luck. All right, people against Castro. Jose Felix Aaron Castro, 19F231230. Your name?
Jose Castro.
All right. Mr. Castro, I don't believe you had an attorney before, did you, sir?
No, sir.
All right, so you pled guilty under section 771.1 to retail fraud. And the agreement was that it would be taken under that statute for a period of 3 months. They dismissed the retail fraud at the time of that of the plea. All that's true, correct?
Yeah.
I did not order a pre-sentence report or any kind of screening. I just set it for hearing, for sentencing, I should say. And that's it. So you have the right to a lawyer. If you want one, I will give you one.
No, sir.
You waive your right to a lawyer?
Yes.
Okay. Is there anything that you would like to tell me before I sentence you?
No, I mean, I've been in trouble, don't plan on being in any trouble with a mistake I should have never, done.
All right, people, again, Castro. Jose Felix Aaron Castro, 19F231230. Your name?
Jose Castro.
All right. So you met with the department rep, the Officer Hirschberger, it looks like, and you two agreed that you would plead responsible for impeding traffic with the speeding to be dismissed.
I'm going down to the court.
3 months probation, I'll take it under section 771.1. You cannot leave the state without consent of the court. You cannot violate any law or ordinance. You cannot enter any Meyer store in the next 3 months. You must report to probation as directed. You're not to go back to 26100 Vreeland in Flat Rock specifically, but you're not going to any Meyer store. Do we understand that?
Yes, sir.
All right. Fines are 150, costs are 100, 75 victims' rights fee, $50 justice assessment. So, and $60 in probation fees. So your total here amounts to 310 plus your 125 for 435. I'm going to order 4 hours of community service. You're to complete that in this case no later than April the 1st. Okay?
Okay.
I'll give you a review hearing date. So again, you owe the court $435. Do you have all that?
I didn't.
All right, so you'll pay that.
He did have a bond too, Judge.
Yes, you have a bond of $300, which is in your name. So that was, let's see, that was 3,000, 10% by law. We keep 10%. So you have 270 to apply. So you'll apply the bond, you'll go down, you'll pay the other 165.
Okay.
John, see if probation needs to see him, if nothing else, to explain the community service, but you have to do community service 4 hours by April 1. You can do that at any nonprofit organization of your choosing. This church, Salvation Army, St. Vincent de Paul, I could care less. It doesn't matter, but it has to be nonprofit.
Okay.
We're going to give you a review hearing date, 3 months. You'll come back. If you've done everything and stayed out of trouble, the case will be dismissed on motion of the prosecutor.
Okay.
So we need one for May sometime
May 14th.
at 8:30, May 14th at 8:30. So you'll go down the hall, pay your fines, apply your bond, get your notice, your paper notice.
Okay.
Then you'll go meet with probation. Good luck.
Thank you.
No more though, okay? You ready, Jack? Mr. Sparrow? Yeah, just hand it to Sadie.
So you gotta go to probate. Okay.
But you're gonna go down and take care of the other business first, okay? People against Charles Faust. Charles Anthony Faust, 267-245-377.
Charles, wow.
All right, so you met with the prosecutor. He's going to dismiss the expired license, and your client's going to plead to allowing an unlicensed driver to drive, true?
That is correct.
That is punishable, sir, by up to 500 fines, 90 days jail, costs are all those. But there is no reporting to the Secretary of State, 0 points, no, non-abstractable. Do you understand that?
Yeah.
Did you sign, read, and understand the advice of rights form here today?
Okay. Yes.
If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. And this is how you wish to proceed?
Yeah.
All right. To that charge, allowing an unlicensed driver to drive, how do you plead?
Guilty.
On January 7th of 26, were you in control of a 2011 Chevy that was being operated on Telegraph, Ypsilanti?
Yeah.
Sorry.
He's very nervous, Your Honor.
Well, there's no reason to be nervous.
I'm not used to this, sorry.
It's all right. Were you in control of that 2011 Chevy that was being operated on that date of January 7th of 26 on Telegraph, Ypsilanti, and Flat Rock?
Yes, sir.
And you were suspended and knew it at the time, is that true? Or unlicensed, I should say?
Yes, sir.
Are you on probation or parole?
No.
Anybody force you to plead guilty? Please accept it. This expired license is dismissed. Anything you'd like to say?
Yeah, I can say my client owns his own business. He does detailing, mobile detailing for predominantly RVs and boats. He has a bunch of work when the weather breaks. He can't do it until then because it won't take. He would just ask for 30 days for fines and costs.
20, anything you'd like to say?
I'll say
25 fines, 20 costs, 75 victims rates, $50 justice assessment. He has a valid registration now, right? You got a valid You renewed your license, right?
Your Honor, and I discussed this with Mr. Kaling, when he gets money, he's getting all that stuff too. Your Honor, he does really, really well in the summer. Unfortunately, maybe with him, he's really not good at it.
How'd you get here today? You didn't drive, right?
Your Honor, his friend's waiting in the parking lot. I know the gentleman that drove him. And that's why he missed last week.
March 17th, you pay by. If you don't have the money by March 17th, you call the court, we'll go on Zoom, I'll give you an extension. You gotta save your money or do something. You can't drive around without a valid license, okay? Best of luck. Higgins, thank you. Okay. People against Ashley, Michelle Higgins. This is 26B 82699 A, B, and C. Your name?
Higgins.
Did the victim's dog seek vet treatment?
She said the injuries were very minor.
All right, so the prosecutor wrote this up. So Heather, we're gonna take out everything I just ordered because there's not a misdemeanor charge here anymore. The prosecutor is dismissing the vicious act charge, so there's no misdemeanor. She's pleading to the 2 civil infractions, and the prosecutor moves to dismiss as defendant has taken collective action to ensure this does not happen again, and complainant does not wish to proceed with charges, which is what you told me. So all I'm gonna do is, so Heather, I enunciated all those bond conditions. I just want to make sure that they're not reflected anywhere, and then I'm gonna take these pleas and fine you on the other 2.
Okay.
So, you understand everything?
Yeah.
All right. To the charge, dog at large, respond. You gotta take the phone out of here, please.
Gotta go.
Phone out of the building.
Did your phone just go off?
Somebody's did.
Somebody's phone, huh?
To the charge, a dog at large, respond. Hang on, ma'am, can you just keep your voice down a little bit for me, please? Dog at large, responsible or not responsible?
Responsible.
No license. You gotta keep your voice down. No license. How do you plead to that? Responsible or not responsible?
Responsible.
Sadie, can you bring her tickets up for me? Could you? Okay, I'm accepting those pleas. I'm dismissing the dog at large. I don't remember what our cost is on those, Heather. Can you tell me?
135 apiece, Judge.
All right, that's good. Thank you. Fines and costs of 135 on each. Can you pay all that today?
Yes.
All right. Good luck to you. Wish you well. Have a great day. 270, 135 each. Yes. Come on.
Morning, Judge.
How are you?
Good, how are you?
Pretty good, thanks.
Did you want that up?
I don't need it anymore. I'm sorry. Morning. Look like you're taking a leisurely stroll. Coffee in hand. And no pressure here. People against Brian Keith Walker. 2-6R-514484.
Good morning, Judge. The apathy will be 82378 on behalf of Mr. Brian Walker.
Brian Keith Walker.
All right, so we moved this sentencing. The defendant had pled guilty previously to operating while impaired. The drunk driving or operating while intoxicated was dismissed. He was referred for a screening and assessment. Have you had the opportunity to review the report with him? And are there any material additions, corrections, or deletions?
We have reviewed the report. There are no additions, deletions, or corrections.
Okay, anything that you would like to say?
Your Honor, just that he has been employed at Brady Plus for over a year. His children are 14 years old, 3 years old, and 8 months old. He's apologetic for the situation. He's looking forward to, I know the drug impact panel is something that's ordered. I've heard from a lot of the clients that they really enjoyed that. It taught them a lot. So other than that, Your Honor, I would ask that you follow probation's recommendation.
Anything you would like to say?
No, sir.
He's got a lot of warrants, so
We discussed those two, Judge.
why are you doing that?
Just recently, I didn't know about it, yeah, so I'm gonna take care of them as soon as possible, as soon as I hear.
You didn't know about it.
Yeah, I had a,
Be careful now. Just be careful.
Yeah.
Okay, I don't want to hear stories, okay? Don't tell me you didn't know about it. I mean, the court never notified you, you didn't have tickets handed to you, you thought they threw them in the garbage, what?
no, I'm pretty sure it's because I moved. And I never changed my address.
You got a high breathalyzer and you scored high on the alcohol use portion. Show your lawyer the AA verification.
Sure, what?
The AA verification. I ordered you to go to AA. So I just want you to know what concerns me there.
No, they didn't, give me a place for any big deal.
He had the sheet, but it was blank, Your Honor.
Yeah.
Because he didn't go.
Oh, I wasn't scheduled,
I told you to go to AA. You weren't listening?
No, I was,
Well, where did you go to AA? Look at
I
me.
was getting my sentence. And they're getting.
You thought I was to follow the orders of court. You scored in category 5 in both the alcohol and drug use portion. That tells me you got a real problem. It's okay, but you're going to deal with it or this is not going to work nicely for you.
Yeah.
So I want to make sure that we understand one another going forward. I'm going to let this go, but you're going to comply with orders or we're not going to get along.
I want to.
Why would I have had him give you the AA sheet if you want to talk about this at that time, if you weren't supposed to start going to AA until sentencing?
Because the guy that I met with first.
Who's the guy?
I don't know. I know.
Is it a lawyer?
Yeah. One of the lawyers in the office. He was explaining to me that they had to give me the location of where I'm going to be. And he was like, when he talks to the probation.
What lawyer? I don't want to know. I don't want to know. Listen. You scored in category 5. I cannot emphasize that enough. 13 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any of government if you change your address, your place of employment, or home telephone number. You must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PGTs and ETGs. I'm gonna make it bi-weekly for 4 months. If you're clean, I'll revert it to monthly. Attend AANA at least twice a week in person. Just listen. You have to go in person. You have to have your AA verification form seen. Every time you come to court, you have to bring that form with you, whether it's in front of me or to the probation department for your reporting. You understand that? You're gonna be going to AA twice a week. I'm ordering intensive outpatient treatment with aftercare. You need to go to that. Once you start intensive outpatient treatment, that's gonna keep your hands, it's gonna keep you busy. You don't have to go to AA or NA anymore. Unless it's recommended as aftercare. Do you understand that?
Yes.
You're also to attend the Victims Impact Panel, which is one night put on by Mothers Against Drunk Drivers. 4 days jail, credit 1, serve 3. I'll let you serve those on the court work program. But you're gonna have to get here and don't be late. Do you understand what I'm telling you? There's 3 days court work. There's a $35 a day charge for that for a total of $105. Pay fines $300, cost $200. $75 victims' rights fee, $50 justice assessment. So fines and costs are $6 1/4. You have to pay $260 in probation fees, bringing your total to $885. You have cost of recovery of $150, bringing your total to $1,035. Plus your court work program fees. Everything included is amounts to $1,140. If you violate, your probation could be revoked, you could be incarcerated for up to 93 days. You may be eligible for early discharge. You get all this done in 6.5 months with no violations, I'll be happy to discharge you early. Probation will explain that to you as well. You're to clear all of your warrants. I'm only giving you until March 17th. So you're gonna clear all your warrants by March the 17th. You understand me?
Can I add something? Do you mind if I get longer?
Why? Why?
I'm trying to keep up. That's the.
You make 600 a week. How much do you make? And you get a bridge card of 391, right?
Yeah.
Well, how 600 a week? How many hours do you work?
Only work 8 hours. I mean, 40 hours. 40 hours.
They pay you $15 an hour. Is it before tax 600 or after tax? So you make what, about 18 or 20?
Yeah.
I'll give you until April 17th. That's it.
Judge,
That
can I
puts
ask you what your total was again? I believe I'm off on what you got.
Sure. Let me repeat it. You'll clear all your warrants. That doesn't mean that if you get stopped, you're not going to get picked up and taken into custody.
No, I just want to
You
make.
got it, what I'm saying? So don't read this as me saying it's okay not to take care of it. If I were you, I'd be running to the courthouse and explaining to the judge. But that's me. All right, let me just double check it. 6 1/4, 685, 885, 945, 1,095. Yeah, you're right. It should be. Yeah, am I right that it should be 1220?
I think I might be missing something then.
I have $60 screening fee.
Mhm.
I have 75 and 50 on the victim's rights and justice assessment, 300 fines, 200 costs, 260 probation fees, cost of recovery of 150, and court work program fees of 105.
I missed the cost recovery. I have 1,200 with a cost recovery of 150. That was the only thing I was missing.
Hang on a second. I'm sorry.
No, you're okay. I just like to make sure we match.
685, 885, 945, 1,095. Yeah, it should be 1,200. Is that what you got?
Yes, that's what I have. We're good now. Okay.
Can you pay all this today? You gotta work harder. Did you got an associate's degree? I don't know why you're only working for $18 an hour. You graduated high school, you got an associate's degree, right?
Yeah, but it was for studio audio engineering.
How much can you pay per week or per bi-weekly, whatever you want? I'll set you up on payment plan. Does he have anything today?
No, Your Honor.
But you got enough to, how much can you pay weekly or bi-weekly?
Bi-weekly. 200.
I don't need you to do two. Do $100 bi-weekly. And I will start this beginning on March the 6th. If you ever don't have the money, call the court. We'll go on Zoom. I'll be glad to give you an extension. Don't ignore me, though. Are you listening to what I'm telling you? All right. Show some respect for the system. I fail to believe that I didn't clearly enunciate that you were to go to AA. Good luck. You'll meet with probation. Have a good day. Are we ready on Intel?
I don't know about you guys, but I watched a little bit of Family Guy here and there. I've been known to enjoy that show. And anytime I hear AA over and over, all I can think of is Road to the North Pole, when they have the car accident up in Canada and this Canadian stops and they start doing this bit about AA. He goes, "Oh, you need AA, eh? Oh, you go there if you're drunk, eh? No, I need AAA. I need help with my car. Oh, you need AAA, eh?" I don't know. It always sticks in my head. Anyways, let's go back to Texas some more, Judge Boyd.
All right. Hello. Is there an application in this?
Yes, ma'am.
Okay. Probation, there's an application. Court is calling 2025 CR 006045 State versus Lily Herrera. Can I have parties announced?
Lindsay Shaw for Miss Herrera.
And are you Miss Herrera?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Herrera, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
All right. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, Ms. Herrera, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of controlled substance penalty group 2, 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? I'm sorry. Did you intend to give up the right to jury trial, the right to cross-examine witnesses, and the right to remain silent? All right. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, ma'am.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Herrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
All right. According to the plea, there's a $1,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, ma'am.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. There be a TAP evaluation. 120 hours community service restitution, the MRT and the DOEP course. You understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor, to offer State's Exhibit 1 and all.
No objection.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Only, Judge, that she does live in Corpus Christi, so we ask that her probation be transferred to Nueces County.
Okay. All right. Do you have any children?
Yes.
What are their ages?
18, 14, 11.
All right. Do they live with you or someone else?
They live with me.
All right. Who are they living with now?
My mother.
All right. Is there a child protective services case involved with this? And does your mom live with you?
Yes.
Okay.
She does have support here with her. Her boyfriend and her grandmother are here in Fort.
Okay. Thank you. So how long were you in Bear County before this incident?
Just 2 weeks.
Okay. And who is the Leslie person who was in the vehicle?
It was her and hers. But
Sorry, what?
There were hers.
No, I mean, who is she to you?
Nobody knows.
Okay. And was that her vehicle you were driving?
No, it's mine.
Okay. And what were you doing at the detention facility?
I was taking her to go see her boyfriend.
So it's Dominguez State Jail. Yes, whenever you go onto prison property, they
I
will
didn't-
search the vehicle.
I didn't-
Okay. And so, and I always ask questions because I'm trying to figure out what conditions are appropriate for people. So when you were driving her to Dominguez, your children were in Corpus? They were here?
No, they were in Corpus, my mother.
Okay. How far did you go in school?
11.
All right. So what do you do for employment?
I was a provider.
All right. So in this court, you know, I don't allow people to be home healthcare providers.
Been there for 2 years.
Okay. So, other than being a home healthcare provider, do you have any dreams, goals, hopes, ambitions?
Well, I'm gonna look for a new job. That most definitely.
But I mean, what's your dream job?
If I could build up my credit, I could like invest in like homes, trailers, so I can.
All right, this is what the court is going to do. The court will transfer to Nueces County. There's to be no unsupervised contact with minors. 3 years deferred adjudication. No contact with Leslie Silguero, Silguero. There's to be 120 hours All right, you have me, Bashan?
Judge, transferred to Lake County, no unsupervised contact with minors, no contact with
Silguero. Silguero. 3 years deferred adjudication. 120 hours of community service hours. I'm going to require parenting classes. Once the parenting classes are complete, the 20 hours will be deemed satisfied. You can obtain your GED or some sort of trade school certification. If you do that, then the remaining of the 100 hours will be deemed satisfied. There's to be regular reporting by Zoom or in person, regular random UAs, the MRT course, DOEP. And probation, I don't know if they do field visits there, but if they do field visits 1 time per month for 6 months. Probation, is there anything else?
no, Judge.
Is there anything else you need from the court to be successful?
No.
All right. Did you review trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. You have children who are depending on you. The range of punishment for this offense, if a motion to revoke is filed, is anywhere from 2 to 10 years in prison. From here on out, everything you do, if you're not doing it for yourself, do it for your children. Be on the straight and narrow. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back here to me, okay?
Okay.
All right, good luck to you.
Thank you.
You're welcome. Who's next?
Yes, yes. Montreal, it's page 8. Yes.
Yeah, Carl Robinson refused to count this. Didn't want
All right, who's here on Monreal?
to. This.
Who's the prosecutor?
Me, Judge.
Monorail? Right here in the middle, please. Thank you.
All right, court is calling 2025 CR 006058B State versus Roberto Monreal. Can I have parties announced?
Jason Goss for Mr. Monreal.
All right, so there's a motion to amend bond conditions to allow for travel. And then there's another motion asking that contact be allowed with a specific individual.
Well, I believe that
It's connected to this.
I don't think that order is the proper order. I think there is an additional motion that we have, but it's kind of a strange one. Pretrial has,
So are we hearing that today?
I think they have 2 different.
Okay, so are we, well, you can't tear it apart because they filed it some sort of way.
Oh, okay. Well, this is a different defendant, so it's not.
No, but I mean, they have to unstaple it because
I'm sorry.
they're filing it legally, however they're filing it.
Yes, ma'am. That would be a different defendant. So we're here on Roberto Monreal.
All right. Okay, you want to go through that? All right, so motion to travel. State, are you opposed?
We're stopped this time, and the reason for that is due to the farmers hospital leg, and we do believe due to the father living in Arizona, that does present a flight risk, and so that's why we want.
My client's 18 years old. The prosecutor referenced the charge. It is a murder charge. This is a situation from the arrest warrant affidavit where that the court could see that there is a.
Oh, I don't have the arrest warrant affidavit in
I
front of me.
understand. I believe it's in the court's file. Usually it's filed as part.
We're
of
paperless,
Okay.
so I don't have
I
that.
understand.
That's okay.
If I could, since you referenced the charge itself, and I think the prosecutor will at least agree on the facts that there was a person who died, but that person was in the same car as my client.
Mhm.
So this was not a person who, he was basically participating in whatever my client was participating in. My client was not a shooter. My client did not have a gun. My client was not involved in that. Now, the only reason I say that for the court is that if considering the charge, that I think those facts are also important. But additionally, his father lives in Arizona. He's 18 years old. He would like to go visit his father. The court has already granted him travel previously in the past where he did travel and he came back. And
That was during Christmas holidays, right?
yes, Your Honor.
Okay.
He's shown the court that he is not a flight risk. He's 18. Like I said, he's 18. There's not really, he doesn't really have anywhere to go, but he would like to see his father. He hasn't been able to see his father since he's been arrested. And so that's why we're asking for that brief period to go to Arizona and to come back, and for that travel to be granted.
Judge Eisel agreed to an extent Mr. Boston's rendition of the facts. It is a felony murder, so there's an underlying felony that was occurring at the time of the murder. And I will stipulate that this defendant was not charged as the principal. And if the court would like, I can produce a copy of the arrest warrant.
And we have no objection to that. If the
All right.
court wants that.
Let me see that. Mr. Monreal, who all lives in the household with your father?
It's just my father, Your Honor.
We're off the record for briefly. Bashan,
Yes, Judge.
so on Montez,
Yes, Judge.
they say they say they're just waiting on the referral. I'm gonna send this to you. Yes, I'll sign it. And we're back on the record.
We can give it to the court. I have a copy digitally, and whatever the court is looking at is fine with me.
For purposes of this.
Yeah, no objection.
Court will accept B1 for purposes of this hearing. All right, court has reviewed B1 for purposes of this hearing. I'll hear final argument.
Judge,
Yes, Your Honor, as the court has reviewed, the person who was deceased was the person that they're alleging was committing the robbery, shot by the alleged victim of the robbery. As the court can see, my client did not have a firearm, did not carry a firearm, and we're going to be litigating this case, but I just wanted the court to understand this, because I know the court knows, but just to see the facts of this case, there's a difference between somebody actively committing violence by taking a gun, shooting a gun at a person. My client didn't do any of those things. And really what we're asking at this point is just to, on this motion, is to have him be able to visit his father. As I said, he is 18 years old, was 18 years old at the time of the commission of this offense. So he is a teenager, and we do think that it's important for him to see his father. We think that by the court giving him the opportunity the court's given him before, and him being able to take that opportunity and to do what he was supposed to do and what the court asked him to do, and follow the rules of pretrial and the bond conditions this court has set upon him. We believe that he's shown the court that he can be trusted to go visit with his father and return. And we don't think that there's any information or evidence the state has provided that that would not be the case.
Okay, this is what the court is going to do. Previously, the court allowed the defendant to travel December 22nd through the 27th, and that was to Denver with family. And are there any allegations that he violated any pretrial conditions while traveling there?
I understand that's when there was no bill by.
All right, this is what the court is going to do. The court will allow you to visit your father. I'll give you the same travel that I've given before, but it's for 5 days. That was the Christmas travel, and this will be for 5 days. So it's 5 days from March 7th. Are you leaving March 7th or a different date? All right, so you'll need to provide that information to pretrial services. So then your travel date that's on this motion, it says March 7th through March 15th. That's not the appropriate travel date?
I believe that it is the appropriate travel date, but as the court has limited that date, I don't know. I don't know necessarily how that would limit as far as where the 5 days are going to be at the end, or the 5 days are going to be at starting from the 7th or coming back from the 15th. Do you see what I mean? And so it might be the 10th or the 11th through the 15th. Or
All right, this is what the court is going to do. The court is going to grant the motion. You're allowed to travel to Phoenix, Arizona in the month of March 2026 for 5 days. There should be UA upon return. And you're to reside at the address that's given in the motion. Is there anything else?
Not for the defense on this motion. There is an issue I'd like to address with the court. I've talked to the district clerk, and they have not been able to. There's a letter his pretrial officer has written to the court. I think the court wanted a hearing based upon that letter. I know, and they couldn't find it either. I don't know if probation might have access to it, but the basic issue is my client would like to apply to a trade school, and he asked his pretrial officer for permission to do that. She did not grant it. She wrote a letter to the court. The school would start in September.
All right, if somebody want to contract, who's the pretrial service officer?
Amir?
Yes.
Amanda Sings.
All right, Norma, see if she can zoom in. Or if you'll let the coordinator know who it is, and then we'll have her zoom in.
Sings.
Sign?
Yeah, Science.
Amanda sign.
All right, just have a seat. She'll zoom in and we'll take up the matter.
Yes. Thanks.
State, do you have any objection to taking up that matter now? No. Okay.
So sometimes here at the bunker, I get busy tracking down other things and I'm not completely listening. But somebody fill me, I'm trying to read in the chat, and it's a little bit, I think, unclear with you guys too. So there was a robbery that the deceased person was committing. There was a car accident. The deceased person was unalived in the car accident, and now this kid's like got a murder charge. Is that what's going on? If you can try to clear it up for me. I mean, I'll watch it back later. This is probably going to end up being a standalone video. I don't know. But I'm a little confused, to be honest with you. No car accident. Okay. I thought there was something about a car accident in there, too. I guess I'm just going to have to watch it back. But anyways, looks like we got a new contestant coming up. So let's just continue with Judge Boyd.
Morning, Judge.
Good morning. How's it going?
It's going.
Let's see.
I'm used to that.
All right, so where are we on the PTD?
It was accepted. He signed, prosecutor signed, I've signed, and we're just going to turn it in.
All right, Ms. Ferguson, I need a PTD date.
March 19th.
All right, just make sure you follow through on everything, okay? Good luck. Once you sign the reset form, you're excused. Who's next?
Yes, it's Angela Boyd. It's the plea. Okay.
Angela Bowl. Counsel, is there an application?
There's not, Your Honor.
Okay. Probation, there's no application. Court is calling 2025 CR 014580 State versus Angela Ball. Can I have parties announced?
Daniel De La Garza for the defendant.
And are you Ms. Ball? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, I'm sorry.
That's okay. Court will find that the state is in compliance with discovery. Ms. Ball, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Ms. Bowl, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession. Oh, just one second. Oh, you're charged with manufacturing and delivering of a controlled substance penalty group 2 or 2A, 1 to 4 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
No, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Ball, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 2 years in the prison, and there's a $1,000 fine and no applications. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor, sheet after states exhibit 1 and not.
No objection.
State your excuse. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just, she takes responsibility.
All right, the court will sentence you to 2 years in the prison, give you credit for any time served. There's $1,000 fine, time and money will run concurrent. There's to be no contact with Austin Escamilla and Johnny Vasquez Jr. So do you want this to run concurrent with parole, or has that been addressed?
Please, it has not been addressed, but I would like it. Yes.
All right, concurrent with, let me see. The parole number is not in here, so you'll have to.
I'll either get it or I'll supplement it with the clerk.
All right, concurrent with parole sentence.
We'll do that today, Your Honor.
All right, and there's to be no residing in households with minors. And no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. How old are you? All right, so look, you're gonna have to start changing your ways. Otherwise, you're gonna find yourself spending the rest of your life at a prison or at jail. You understand? And here's the other thing. When you're doing these type of things, that's you building your happiness off somebody else's misery. You can't do that. No good will ever come of that, okay? All right, when you're released from prison, if you need help staying on the straight and narrow, if I'm still here, you come back. I'll help you find a place to help you, okay? All right, good luck to you. You're welcome.
Thank you very much, Your Honor.
You're welcome. Who's next?
Carl Robinson, H2 down. Please again. The next one.
Carl Robinson.
Present, Your Honor.
Hello.
I'm going to continue to ride with Judge Boyd for now, just to see if that previous hearing somebody zooms in like they were looking for. And thank you, Ashley and Great Granny and the rest of the chat for trying to bring me up to speed on that. Again, I just missed key parts of it as I was researching some other stuff.
Some discovery documents he was looking at. He couldn't take back with him to the jail cell, to the jail, you know. Regardless, Judge, I'd like to get a reset for it, and I'm still talking to the state.
All right. Norma,
Yes, sir.
set this in 2 weeks for a jury trial. And Deputy Laura, he'll need to be dressed.
Yeah, March 3rd.
Now, can you do it on March 4th?
Sure.
Judge, I'm gonna be out of the country March 9th through the 13th, so I don't think our trial is gonna be able to resolve in 48 hours.
You say March when?
March 9th through the 13th. I'll be out of.
Well, let's see what happens. Let's see where we are.
We can always try and
Yeah.
see where we're at.
All right, Norma, put it for March 4th.
Okay.
And I'll notate that you're supposed to be out of the country. Where are you gonna be?
My wife are going to Israel. If Trump doesn't bomb Iran.
Oh, okay. See, we know what may happen.
You know how that goes.
Okay.
Carl, okay. Maybe excuse judge?
Yes.
Thank you.
All right, who's ready?
Christian Garza, speak one at the bottom, Judge.
Christian Garza. All right, are there applications?
No, Judge.
And there's just a plea on one case?
Yes, Judge, TIC the rest.
All right, the court is calling 2025 CR 014939 State versus Christian Garza. Can I have parties announced?
Brandon Brennan for the state.
John Pettis for defense.
And are you Mr. Garza? Okay. Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Garza, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Judge.
Counsel, do you waive the reading?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Judge will be proceeding solely on count one, waiving and abandoning the remaining counts.
Any
No objection.
objection?
No objections, Judge.
Mr. Garza, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
You're charged with aggravated robbery in count one. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and was, Judge.
Mr. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Sorry?
Are you satisfied with the way you've been represented?
Yes, Judge.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, Judge. Exactly.
Okay, that's good.
Yes, Judge. Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 8 years in the prison. State will take in consideration 2025 CR 011050 and 2025 CR 011063. If the court finds that a weapon was used in this case, then there will be an affirmative finding of a deadly weapon by the court. Did you understand?
Yes, Judge.
Is that the agreement, defense?
Yes.
State?
That is your agreement, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Judge.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged in count one, how do you plead? Guilty, not guilty, or no contest?
No problem.
State any evidence.
Judge, we have to state exhibit number one, including all of its attachments.
No objection, Judge.
All right. And state you've spoken with the complainant?
We have, Judge.
Thank you. You may be excused.
Thank you.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We're asking for a reset for sentencing, judge, just to allow him to get his affairs in order, and then
Oh,
Okay. Let's just mute. I'm a little bit in the Wayback Machine here, though, so let's try to move forward from that.
so much.
There we go.
All right.
okay, judge, I mean, doesn't seem like we have a choice.
Yeah. My hands are tied.
There's no legal reason, I guess.
Okay. So the court will find you guilty. The court will sentence you to 8 years in the prison, give you credit for any time served, take in consideration 2025 CR 011050 and 2025 CR 011083. And there's an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Thank you. Yes. Hello.
Hi, good morning, Judge.
Good morning. How are you doing today?
I'm good, thank you. How are you?
Oh, I'm doing great. Thank you so much for zooming in. I really appreciate it.
Not a
All right,
problem.
people on Roberto Monreal. Megan, do y'all need to talk to her in a breakout room? Okay. Oh,
Thank you, Judge.
you're welcome. Sorry about that. All right, we're on the record in 2025 CR 006058B, State versus Roberto Monreal. Can I have parties announced?
Megan Galley for the state.
Jason Goss for Mr. Monreal.
And are you Mr. Monreal?
Yes, Your Honor.
All right. The defense is requesting that he be allowed to apply to a trade certification or some type of electrical apprenticeship program. And we have the pretrial officer by Zoom. Any objection to the pretrial officer appearing by Zoom?
None from defense.
All right. So state, do you have any objection to the defendant being allowed to apply for this program?
Judge, I guess my objection would be if then he's going to be asking for partial to attend school. And the reason for that is because the magistrate in this case that wrote the warrant viewed the evidence, and I know Mr. Voss is, it's going to be litigated at some point. However, judges are allowed to place conditions upon a defendant that is charged with a crime based on what they believe is for community safety. And so in this case, based on, and I would reoffer State's Exhibit B1, but what that represents to us is that the defendant was aware of and participated in the underlying felony. And I know they're contesting aspects of that. However, the law of parties provides that under state law, he is to be charged with the offense of murder. And so for those reasons, we are not in agreement.
Your Honor, if I could provide just a little bit more information to the court, the school is not set to start until September, but the issue, as the court probably knows, is that the application process has to go through and he has to either be accepted or not. We're just asking really for the first part. Obviously, if the school did start, I would agree with Ms. Galloway. We would be coming to the court and asking for permission to
Well,
attend.
don't you apply online?
No, no, it's, I have to go in person to apply.
Mhm. All right, and pretrial services is the only reason you're not allowing him to do this is because he's on full GPS?
That's correct, Judge.
Okay. All right, thank you so much. Do you all have any more?
No, Your Honor.
All right, you can remain on to see what my ruling is going to be.
I appreciate it. Thank you.
Thank you. And where is the location for you to provide your application? All right, so the court needs that information before I'll even consider doing it.
It should be with the breach permissions. I'll let my officer know.
All right, so the document I have before me, they were able to give it to me. They gave the name, but there's no address listed. So,
Is it in San Antonio?
Yes.
So it is in San Antonio.
you know, I need the address for me to even consider doing it.
Your Honor, can I get the name of the place?
All right, if you all step back.
Yes, Your Honor.
All right, thank you so much, Ms. Sines. You can remain on, or either we'll send word to you what my final decision is. All right, thank you. All right, Rick Contreras. What page is Contreras on?
Page 9.
You're on the
down
middle. Good morning, Your Honor.
Morning, doing okay. All right, is this a motion to revoke?
That's correct.
And are we proceeding on the motion? Mr. Cox, are we proceeding on the motion?
I think we reached an agreement that
Okay. All right, so we're proceeding on the MTR?
Yes, Judge.
All right. Court is calling 2021 CR 2910W State versus Rick Contreras. Can I have parties announced?
Megan Galloway for the state.
Cornelius Cox for the defendant.
And are you Mr. Contreras?
Yes, ma'am, I am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Rick Anthony Contreras who was placed on deferred adjudication in 2021 CR 2910W for the offense of possession of a controlled substance? Let's go off the record.
Okay, once again, we are still a few minutes on the way back machine, so let me try to bump this forward.
10W for the offense of possession of controlled substance, penalty group 2, 4 to 200 grams on March 30th, 2021 for a period of 4 years and extended for a total of 2. Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 2 on or about the 13th day of January 2026 in Bear County, Texas. The defendant, Rick Anthony Contreras, did their fail to submit to drug testing in violation of condition number.
How do you plead to that? True or not true?
True.
People waive and abandon their refusal.
No, good.
All right, did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is to deny the state's motion and alter and amend the conditions for safety along with health.
All right, and that's the post for,
Yes, Your That's it.
here's the thing. I do not know if you will be able to successfully complete this because this is not your first motion to revoke. And we're here for the same violation. So I'm going to give you a choice. There are no other choices. These are your only choices. One, I will revoke you and I will sentence you to 3 years in the prison, or either I will continue you. And when I continue you, I'm going to extend you and you're going to safety and you're going to remain in custody until transferred to safety. Which do you prefer?
Well, counter proposal. Just in terms of, my client, he's willing and wanting to go through the safety program.
Okay.
And so that's not an issue. We agree that's not an issue. And his situation, Judge, is, you can see, it's been a constant struggle with the drugs. But it's not a situation where he just given up on that struggle. He's been in the fight, and although a lot of times the drugs have an upper hand, but he's still fighting the fight.
Yeah. So I mean, that's why I'm giving him two choices.
Right. So I understand, well, the prison, that's always the case. Not a solution, good choice. What we would ask the court to do is allow him to go to the safety program.
Oh, no.
When he comes back, then the court has some other assessments in terms of whether he needs. Then I would prefer the court make a decision. Then the court would have an opportunity to get an update from the program, how well he's doing, and get an opportunity to see.
Oh, no. I'm just asking, if you want today, I will revoke you and sentence you to 3 years in the prison, or I'll deny the motion and you can go to safety. Those are your two choices.
We agreed on the safety.
No, I mean, here's the thing. You know yourself better than I do,
Yes, sir.
better than anyone else. So that's why I'm giving you the two choices. I am hoping that you choose safety. I'm hoping that you'll be successful. But I'm just saying, based upon this is not the first time that you've been before me for a violation of number 2. And I've added conditions to help you. I just don't know if you will be successful. So therefore, I'm giving you two choices. 3 years in prison, or either you remain in custody for transfer to safety. Which do you prefer?
Safety.
Okay. All right. Ms. Abrams? 2 will be true. Deny the motion, alternate amend conditions. He's to remain in custody for transfer to safety. Or if felony drug court accepts him, he can go to felony drug court. That's it.
Okay, I already fell in the first one.
Oh, it's completely up to them. I have no control over your being placed in the program, but yes.
Judge, I don't think felony drug court, is gonna accept him.
Oh,
And you can talk to her and she'll tell you why. All right.
that's fine.
Thank you.
Thank you very much, Judge.
Thank you. Just give me one moment. Yes.
In order for him to be on, go to safety, he has to have 2 years remaining on probation. At this point, he only has a year remaining.
All right, so we're gonna have to extend him. And extend him for the 2 years.
Here,
Yes. Sir, you're gonna be extended for 2 years because of the program.
If he completes successfully, would the court entertain early termination?
Always am available to entertain any motions that are brought before me.
Thursday, that's for Frisk. Thank you.
All right, thank you. Who's this?
Yes.
Then I have one more to give you. If Odyssey wasn't moving so slow. And it keeps saying no match found. Yes.
Just wanted to return the letter, and I've written the address on there, so the court has the address.
All right. State on this Monreal matter. All right, and what date would this be?
That's for sure. That's it.
I think at the time, he'll have to call and get the appointment scheduled, and we weren't gonna do that unless we knew that the court was.
All right, I will tell you this, the fact that I'm allowing you to apply for that doesn't mean that I'll allow you to attend. I haven't made up my mind on that, but I will not make a ruling on this until you give me a specific date and time. Okay?
Judge, would it be possible for him to call pre-trial that day and then?
He has to give it to me because I have to make a ruling on it.
Yes, sir.
All right, thank you.
So just so I know.
And he can appear by Zoom.
He can appear by Zoom, or would we be required to file another motion or a different motion?
No.
Okay, thank you, Judge.
Who's next?
Page 2 at the bottom, Melissa Guajardo.
Marissa Gallardo. All right. Where we're in Discovery, I know we had a warrant or something.
They did tender the search warrant, Judge. I'm happy to sign off on the discovery acknowledgement. I was given an offer of pretrial diversion, so I'm going to submit that application at the fourth floor today and just hoping for time for that process to occur.
All right, I need a PTD date.
March 19th.
All right, so y'all just make sure everything is filed with PTD, the application, before you come back on March 19th.
Will do, Judge.
Once you sign that, your excuse.
Thank you, Judge.
All right, thank you.
Judge.
Yes. All right, who's next?
House, Tory House. It's a plea, Judge.
What page?
You go do 3 down.
All right, House.
On.
Is there an application? Probation, there's an application.
Already told her, Judge.
Okay, thank you. And is there just a plea on one?
Correct. There should be 2 dismissed tendered for you.
All right, court is calling 2025 CR 013596 State versus Tory House. Can I have parties announced?
We're underway for Mr. House.
And are you Mr. House?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. House, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
See, this proceeding on count one paragraph F, Your Honor, we will waive the remaining paragraphs.
Any objection?
No objection, Your Honor.
I'm so sorry, State. If you can write another dismissal, because they like to sign their own, I should say. Mhm.
Also give it to Judge Key.
Okay, thank
Got
you.
it.
All right, Mr. House, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, and count one F, you're charged with burglary of a building. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? If I were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. House, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one, paragraph F. There's a $1,200 fine. State is recommending deferred adjudication. They're taking in consideration 2025 CR 013595, 2025 CC 015356, and there's to be restitution, if any, to the following per.
Yes, ma'am.
Defense?
Yes, Your Honor.
State.
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be a TAP evaluation, 120 hours of community service restitution, the anti-theft course, a felony drug court referral, and if not accepted, safe P. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count one, paragraph F, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Your Honor, state offers states exhibit 1 and all.
No objections.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Just that the court follow our agreement.
All right. So do you have any children?
No.
Do you have any family support?
Yes.
They are present in the courtroom, Your Honor.
Okay. How far did you go in school?
College.
Okay. So how did you get on this path?
Just being around the wrong people and just not following like the path that I was on out of school.
Well, you know, when people come before me and they say they're around the wrong people, like the other suspect in this case, if I were to talk to him,
Right.
he would say, I'm around the wrong people. And I'd say, who would that be? And he'd say you.
Right.
So how old are you?
I'm 33.
All right. And so how long have you been using?
For like 5 years.
And what were you using?
Right.
Okay. All right. So it's obvious that you're going to need some help with drug addiction. And is his family members going to allow him to live with them if they?
That was part of the issue that we were discussing, Your Honor, hence why we, after conferring with the state, they want him to go to felony drug court, and if he's not accepted, to go to safety. And upon his release, if he's successful on this rehab, then they would consider him being able to live with his mother.
So his mom is here?
Yes, Your Honor.
Can I speak with her?
Sure.
All right. If she'll come up.
Might have difficulty. She is in a wheelchair.
Okay.
Let me help her.
Sure. Hello. All right, so here's the thing. I'm going to grant his application for probation. But when people have drug addictions, it has to be a global support system, right? Probation can't help him if you're not helping him. So that means if he does come to stay with you, you're going to have to lay down the law and there's going to have to be consequences. And if he's not following those, you're going to have to pick up the phone and call probation. Your attorney will tell you if somebody is on probation and they call probation and say, hey, you know, I think I'm going to use, you know, what's going to end up happening in this court? I'm going to set it for a compliance hearing. They're going to come in and we're going to see what help we can give them. But we can't have people disappearing and not reporting. And then they don't report and say, well, I got afraid, so I never show back up, because that limits options.
That's the circle we've been in.
All right.
We've done rehab. We've tried rehab.
Okay.
And I've been in the circle with my son. And that's why I was talking with this attorney, explaining that just throwing him back out there, I don't think we'll be setting him up for success.
Okay.
To be truthfully honest. So when they said inpatient treatment, I think that would be the best.
All right. So
I'm there to support. I'm 1,000% for my children, but I don't want to see him come right back up again.
but you're strong enough for him to have consequences for actions.
Yes.
All right. So I can tell you what I'm going to do. I am going to refer him to felony drug court, and you'll need to talk to them to see if they have room for him.
I already talked to Rashad about that, so
Okay.
it should be good.
And then what I'll do is, if he's accepted a felony drug court, I am going to put him on GPS with a curfew. And so we'll know where he is.
Would the court consider waiving the GPS fees just because of his
yeah.
indigency status?
Yes, the fees will be waived, but that's so we'll know him. Because right now he's going to have to build up his level of trust with probation, and felony drug court makes them build up the level of trust before he's allowed to do other things. All right, other than the drug treatment, is there anything else that he needs?
No, I think that's, maybe mental health.
Okay. A felony drug court, they have a dual diagnosis program, so they'll address any mental health issues with any substance abuse.
Yes, and I think between those two, he'd be smart. Academic scholarship to Texas Tech.
Okay.
Smart kid.
Mm-hmm.
Youth orchestra.
Oh, wow.
Youth orchestra. He can play violin, viola, cello, bass.
Oh, wow.
He was very talented. He got mixed up with the wrong people, and I couldn't get him back.
All right. Well, we're going to try to get him back on the right track.
He's a good kid. He really is.
Okay.
It's down in there somewhere. We just need to find him again.
Okay. So I'm going to grant his motion and we're going to see about getting him some treatment. So if felony drug court doesn't accept him, that means he'll be going into an inpatient treatment. And even if he's accepted in felony drug court, they'll set his conditions. So they may decide he still needs inpatient treatment as well. Okay.
Thank you so very much.
All right. You're welcome.
And just,
Thank you.
can you state your name for the record?
Yes, Vanessa Smith.
Okay.
Thank you.
All right. Thank you. And if you'll make sure she gives probation her information.
Sure, Your Honor.
All right, Mr. House. All right, so this is what I'm going to do. When's the last time you had any type of employment?
It's a couple years.
Okay. We're going to do our best to get you back on track, all right? So I'm going to send you to 4 years deferred adjudication. There's to be a referral to felony drug court in custody. They'll probably be able to see you on Tuesday because it's late in the week. If not accepted, then SafeP. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home healthcare provider or with minors. Partial GPS for treatment, waive GPS fees, field visits 1 time per month until further notice, 120 hours of community service restitution. There's a $1,200 fine that will be probated. Taking consideration 2025 CR 013595, 2025 CC 015356. Restitution and no, if any, and no contact with the following. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, you're gonna have to do better. If you don't do it for yourself, do it for your mom. Get back into playing your instruments, okay? All right, good luck to you.
Thank you, Your Honor. Very
Welcome.
brief.
Yes.
Have a seat, sir.
So I will say this as we bring this day to a close. This is one I'm actually rooting for. That's not always the case. You know, sometimes we run across people where it looks like they've just gotten themselves into a bad way for whatever reason. But it sounds like this dude's got some talent and some brains and, you know, should probably be making something of himself, and he just hasn't, for whatever reason, been able to get there. So fingers and toes crossed that this works out for him. Because it sounds like, if nothing else, his mom's behind him. So hopefully. Anywho, I hope you had a good day today. I did. Today was a good day, I thought. some good court, some good conversation. This is kind of what we want to do here. And we'll be back tonight, speaking of good conversation, 8 p.m. Eastern, 5 Pacific for Sidebar. So join us for that. And of course, we'll be back here for Super Friday tomorrow morning, 9 a.m. Eastern, 6 Pacific, a half an hour earlier for channel members. Do have yourselves a great day. And again, I hope to see you tonight. And if not tonight, tomorrow morning. Take care. God bless.